Good afternoon and welcome to the Judiciary Committee. My name is Justin Wayne. I represent Legislative District 13, which is North Omaha and Northeast Douglas County. We will start off by having senators and staff do self-introductions, starting with my right, Senator Ibach.
Thank you. I'm Teresa Ibas, Senator from District 44, which is 8 counties in southwest Nebraska.
Suzanne Geist, District 25, here in Lincoln.
Angelina Pierre, West Committee Clerk.
Good afternoon, Senator Carol Blood, representing District 3, which is Western Bellevue and Eastern Papillion, Nebraska.
Rick Holcroft, West and South Sarpy County.
Good afternoon, Barry DeKay, District 40, representing Holt, Knox, Cedar, Antelope, northern part of Pierce, and most of Dixon County.
Also assisting us is our committee pages, Logan Burtek from Norfolk, who is a political science major and criminology major at UNL, and Isabel Cole from Omaha, who is a political science and pre-law major. This afternoon, we will be hearing 5 bills, and we will be taking them up in the order listed outside the room. We'll have one joint hearing, which will be LB 106 and LB 107. On the tables to the right of me is a blue testifier sheet. If you are planning on testifying, please fill out the blue testifier sheet. That make sure we have accurate records. If you do not wish to testify, or you heard somebody say the exact same thing that you're going to say before you come up, you can also fill out a gold sheet, and it'll let you know let us know that you wanted to speak or you wanted to record your presence, and it'll list your position on the bill for the record. Also note that it's the legislature policy that all letters of record must be to the committee noon day prior to the hearing. Any handouts submitted by the testifier, we ask that you have 10 copies. If you don't have 10 copies, please provide them to the page ahead of time so we can have them for your testimony. Testimony will begin with the introducer providing an opening statement, followed by supporters of the bill, then those in opposition, and then those in neutral capacity, and then we'll have the introducer close if they choose to do so. We ask that you state and spell your first and last name for the record. Because of the temperature, our heating and air will be going on and off, and you can probably already tell the acoustics are not very well in this room, so please speak up so we can hear. We will be using the 3-minute light system. That means if your testimony starts, it'll be green, it'll turn yellow at the 1-minute warning, and then red, we ask you to wrap up your final thoughts. I would like to remind everyone, including senators, to please turn off or silence or vibrate your cell phone. And with that, we will begin today's hearing with LB 137. Senator Geist, welcome to your Judiciary Committee.
Thank you, Chairman Wayne, and good afternoon, members of the Judiciary Committee. For the record, my name is Suzanne Geist, SUZANNEGEIST. I represent District 25, which is the southeast corner of Lincoln and Lancaster County. This past interim, I met with families who have lost loved ones due to fentanyl-laced drugs. I introduced this bill for Taryn, for AJ, and all the other victims who ended up dying from an accidental fentanyl overdose. You'll hear in a little bit about Taryn and the Griffith family. The story of their beautiful daughter inspired this bill. Taryn was a beautiful young mother who was trying to make better choices for her and her daughter. Every story that I have heard when I speak with parents, they have children that have had great opportunities to look forward to, but for a variety of reasons, they've either relapsed or had a substance use problem. However, they did not know that what they were taking was laced with fentanyl. Many of them were trying to change to be role models for those around them. Unfortunately, prosecutors cannot charge in Nebraska courts the person who manufactured or distributed the drugs in these instances. According to a World Herald article, between 2018 and November of 2022, at least 256 Nebraskans died from poisonings and overdoses on fentanyl and other synthetic opioids. 138 of these deaths occurred in 2021 and 2022, so that's over half of the deaths since 2018. So we're seeing an increase as we go further. We've been hearing in the news more and more that law enforcement agencies are seizing fentanyl pills or fentanyl-laced pills, and I contend something needs to be done. This past interim, I researched the best way to hold someone accountable when they knowingly manufacture or distribute a controlled substance that results in death or serious bodily injury. I looked at different ways to accomplish this in statute and decided the best way was to allow for an enhanced penalty. The federal government also allows for an enhanced penalty in this exact same instance. By allowing for an enhanced penalty and not specifically defining fentanyl in statute, we are creating the ability to hold someone accountable when and if a new, more potent drug makes its way to the streets of Nebraska. This bill will allow Nebraska to be proactive instead of reactive to fentanyl and any newly emerging drug. You may hear from a few behind me that we shouldn't mention in our bill about severe bodily harm, and I just disagree. They will tell you it's broadly defined in our current statute. And even though this may be true, there is case law that discusses severe bodily harm, and that case law describes how the person will never be the same again because of the actions taken. At the end of the day, we all know that the prosecutors who see the totality of the crime will have the final say on whether or not a person is charged with an enhanced penalty. With all these things in mind, I ask for your support. I'd be happy to answer any questions. Know that there are people behind me that have far more depth of expertise in this area than I do, but I'll be happy to answer anything I can.
Any questions from the committee? Seeing none, thank you for being here. Well, I'm assuming you'll be here for close.
I will.
First proponent. First proponent. Welcome.
Good afternoon. Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Mike Guinan, Mikeguinan, and I am the Criminal Bureau Chief for the Nebraska Attorney General's Office. I appear before you today on behalf of the Attorney General, Mike Hilders, and the Nebraska Attorney General's Office in support of LB 137. According to the DEA data, Nebraska law enforcement officials agencies seized over 1,738 pounds of meth and over 167 pounds of illicit fentanyl last year. The DEA, citing 2022 CDC overdose data, states that 2/3 of overdose deaths in the United States involve fentanyl or some other illicit synthetic opioid. Nebraska DHHS overdose data from 2020 found that the largest percentage of deaths by overdose in Nebraska involved illicitly manufactured fentanyls, 34%, followed closely by methamphetamine, 31%. As according to the DNA, only 2 milligrams of fentanyl is considered potentially lethal dose. The increase of risk associated with increasingly powerful and increasingly available illicit controlled substances like fentanyl and carfentanil merits the changes proposed in LB 137. Nebraska homicide statutes do not currently contemplate the situation where an individual illicitly distributes the drug to another who then dies after ingestion. LB 137 aims to address this deficiency by increasing penalties for distribution when death or serious bodily injury follows. These provisions are modeled after similar provisions in the federal law, which increase penalties for the distributor when death or serious bodily injury follows. For instance, if an individual were to manufacture, distribute, or possess with the intent to distribute a kilo of illegal, highly addictive opioid Schedule I drug heroin, under federal law, he would face 10 years to life. However, if death or serious bodily injury resulted from such use of the distributed drug, he would face 20 to life. Under Nebraska law, if the individual manufactured, distributed, or possessed 28 to 140 grams of heroin, he would face 5 to 50, and the same if death or serious bodily follow. LB 137 would increase the penalty by one classification level where death and serious bodily injury follow. LB 137 does pattern off the federal law, which bases the sentence for death or serious bodily injury on the type or schedule of the drug and not on the death or serious bodily injury itself. Thus, under federal law, a Schedule 1 or 2 drug resulting in death or serious bodily injury would result in a 20 to life sentence, whereas a Schedule 3 drug would, the dealer would face up to 15 years of incarceration. To the contrary, a number of states have passed homicide laws addressing a drug-induced homicide punishable at a fixed level or a fixed range.
Thank you for your testimony. Any questions? I got a question. So
Sure.
what would be the element you would have to prove underneath this?
The prosecutor would have to prove the amount, depending on what level you're at, right? So the amount of the illicit drug, plus the distribution, plus the proximate causation of the death that followed.
So that's kind of the proximate. You said the word better than me right now. So if somebody were to sell something, how do you know, how would you distinguish if they didn't add anything to it?
That would be the challenge, Senator. That would be the challenge if you were going to prosecute, right? So you would have to know that this is the drug that was distributed, and that was the one that was ingested, and that proximately caused the death. Those would be elements that the state would have to prove.
I guess what I'm trying to figure out is is this workable?
Is it
I
workable?
mean, yeah, so unless you had somebody say, I mixed X, Y, and Z and sold it, or you were there. Well, no, I mean, you could be there at the time of distribution. But if you didn't have eyes on them, how do you prove that next element that it was actually not mixed? That's what I'm trying to figure out.
Those would be the questions that you would have to address and based on your investigation. Right. So it would, in that event, it would be a challenging set of facts in order to prove your case. So you'd have to just digest that information and make a determination whether or not you're going to charge it.
I know what we're trying to solve. I'm just trying to think of there's a different way. That's all. So thank you.
Yeah.
Any questions from the committee? Seeing none, thank you for being here.
Yes, thank you.
Next proponent. Welcome back, sir.
Thank you, Chairman Wayne, and members of the committee. My name is Patrick Condon, Patrick Condon. I'm the Lancaster County Attorney. I'm here in support of LB 137. I would say that in my 32 years of prosecuting here in Lancaster County, there has been one occasion which I have charged, I think it's getting to what you were mentioning, Senator Wayne, but there was one occasion where I charged a manslaughter charge in conjunction with the delivery of methamphetamine. And that was because we had the individual test or waived Miranda and stated that they had actually injected the methamphetamine into the woman that ended up dying. So that is the only time that we have had that happen. But I think there are specific facts of where the defendant, they make these deals. There'll be 2 or 3 of them there, and 2 or 3 of them will be there. And we had a case this past in the summer during the time where we're having the cocaine and fentanyl overdoses, where individuals were brought back, 1 or 2 individuals may be brought back by the use of the Narcan, and then another individual died. They can testify that they bought this controlled substance from this individual. So we can have them say that they tested, that they bought the controlled substance, they used it, and they almost died. And in one particular case, the individual did die for the use of that, from the use of that laced cocaine. So it is, as Mr. Guinan testified, it is something that we have to look at and that we can look at through the facts, but it is something that we can develop through the facts and through the investigation. This bill also, and I appreciate not naming a specific drug because I just recently had another case where it was pentobarbital that was the cause of death. And pentobarbital is something mainly used in animals. So, people get that. And so this bill allows us to basically take this one step further. So if somebody is delivering a controlled substance such as methamphetamine and it leads to death, it would seem that should be a higher penalty classification than just simple delivery of that controlled substance. And this bill allows us to do this by using the enhancement provision of it. So again, the Lancaster County Attorney's Office is in support of LB 137. And with that, I would take any questions.
Senator Decay.
Thank you. How far back in the chain of events can you look to prosecute? Say if you have a dealer that sells to one party and they sell or give to another party that ultimately dies from it, can you go back? How many?
I think in looking at this bill, it talks about the bill looks, as I read it, looks to the immediate person you're delivering to. So if I deliver it to you and then you deliver it to Senator Holcroft and Senator Holcroft, something happens to him, I think you could be charged. And that would be something where perhaps through a conspiracy, that is, if we charge as a conspiracy, it could be used for an enhancement in the way of a conspiracy.
All right, thank you.
So I just kind of want to, I was about to say tease it out. I really don't like when Conrad says it all the time. So I'm in education, so I'm not going to use that word because she uses it too much for me, and I use it now too much. So what happened with the gun laws is there's a kind of a misnomer. If we don't charge them, the feds don't charge, right? But that's not true. When we changed our gun laws to add a mandatory minimum, what the feds did was say, you take them now and you bear all the costs of incarcerating these individuals, and it's a hard 3. Right now, are the feds picking up these cases?
The ones that happened in Lancaster County, the feds did pick up that individual, that case. That was the one involving the individual stealing from the Nebraska State Patrol.
So and Senator Geist, I'm all in favor of trying to figure out this fentanyl thing. I'm just trying to figure out how we don't do the same thing we did with the guns, where the feds now walk away and say, you charge it all, and then we bear the cost of housing them. I think in the fiscal notice says about $11,000 per year for an inmate. So it isn't like these people are going to be back out on the streets. Just the feds would charge them and they would bear that cost. And again, I'm thinking about a prison. Sure. You think there's some language we can do that, keep the feds a little maybe harder sentence so they pick up the case versus us picking up that case?
Well, and just because of your profession, Senator, I know you're an attorney also, you understand. I mean, in the federal side, I think it's 82 days on a year for a federal sentence, where for state side it's day for day. So there's still kind of, and I don't think the feds would necessarily say we're not going to take this, depending on the nature of the crime. I mean, I think they have other thresholds that need to be met before they take the crime.
Right.
And I'm not sure what those are. I think in regards to the gun cases, I think they've enhanced those penalties now maybe to 10 years on some cases. So there is still the opportunity for the feds to take those. But I understand what you're saying, and I just think, the thing is from, I necessarily can't make a federal case sometimes, and that's
the issue.
That's why I would appreciate this.
Understood. Thank you. Any questions? See you. Thank you for the dialogue. I appreciate it.
Thank you.
Next, proponent. Welcome.
Good afternoon. I'm Jennifer Bogdanoff, Jennifer Bogdanoff, and I am speaking on behalf of the Omaha Police Department in favor of Bill 137. I am currently assigned as a sergeant in the narcotics unit. In 2017, we noticed a significant increase in overdose deaths in Douglas County. Overdose deaths continue to be on the rise and even tripled the number of homicide-related deaths. For example, in 2021, Douglas County reported 92 overdose deaths and 32 homicide-related deaths. We have seen an increased trend in drug dealers selling counterfeit pills pressed to mimic legitimate pharmaceutical medications such as oxycodone, Percocet, and Xanax. The DEA reported in 2022 of the fentanyl-laced fake prescription pills that they tested, 6 out of 10 contained a lethal dose of fentanyl. In 2021, the Omaha Police Narcotics Unit conducted an audit of drug lab results pertaining to the oxycodone or M30 pills that had been seized by the Omaha Police Department and tested. All of the oxycodone/M30 pills that had been submitted to the lab for testing came back as containing fentanyl and not oxycodone, so they were all counterfeit pills. Fentanyl is highly addictive, very lethal, cheap to manufacture, and easily accessible. During interviews with victims that have survived an overdose, they have advised investigators that they believe they were purchasing legitimate prescription medication, even though they were not buying it from a pharmacy, but from a drug dealer. We also see fentanyl mixed with cocaine, heroin, and methamphetamine. A user thinks they are taking a hit of cocaine and end up overdosing because unbeknownst to them, the substance also contained fentanyl. The Omaha Police Department recognized that overdoses and overdose deaths were a very real concern or problem in the Omaha metro area. In an effort to combat this growing problem, in September of 2022, the Omaha Police Department partnered with the Omaha DEA to investigate these incidents. The OPD and DEA have pooled their resources and expertise and have begun responding jointly to suspected overdose death investigations. They are working together in an attempt to identify the supplier of the drugs to the overdose victim and are presenting these cases for federal prosecution. At this point in time, the only prosecutorial option available is to present the investigation to the U.S. Attorney's Office for federal prosecution. Overdose deaths affect all walks of life. Addiction knows no boundaries, does not recognize race or socioeconomic status. Addiction can literally happen to anyone. 25 out of 50 states currently have a drug-induced homicide type of statute. The passing of LB 137 would be another tool for law enforcement to battle the war on drugs in Nebraska. It would put the drug dealers on notice that law enforcement, prosecutors, and citizens of Nebraska take this issue very seriously, and they could be held accountable for their actions.
Any questions? Senator Kay.
In your opinion, and with your experience of, why would fentanyl be mixed with other basically lethal drugs? Is it to enhance the addiction, or is there a reason to do it that would want to cause bodily harm to somebody?
A lot of times the users and or the dealers may not even know that fentanyl is being laced with the cocaine or methamphetamine. It may be coming from their source countries that way. The information that I have read is that the Mexican cartels have said that we like to have our fentanyl stronger here in the United States. They know that it could be a lethal amount, but that a lot of the fentanyl users do like to have it stronger. And so they have been making it stronger. So that I don't have a great answer as to why. A lot of times they don't even know that it may be laced with fentanyl.
Thank you.
So in those cases, are the feds picking it up or are they not picking it up?
They do pick up some of the cases. The issue that we're starting to see is that in Omaha, the U.S. Attorney's Office is wanting to only accept cases that are associated with a federal law enforcement agency. So state and locals are not able to just present these cases like we have in the past. That's new this year. And so they're rejecting some of our Omaha police submitted cases.
Thank you. Any other questions? Seeing none, thank you for being here. You can only testify on one bill today.
That's good.
All right.
Yes, too.
Welcome, sir.
Chairman Wayne and members of the Judiciary Committee. My name is Pat Dempsey, P-A-T-D-E-M-P-S-E-Y, and I'm a homicide detective with the City of Omaha. I also serve as a secretary for the Omaha Police Officers Association. I am here today in support of LB 137 and the legislative opportunity here before us to hold drug dealers accountable for the death and devastation they continue to cause in our community. As you certainly know, the manufacturing and distribution of fentanyl is destroying lives everywhere including Omaha and the whole state of Nebraska. This is legitimately the deadliest overdose crisis in the history of our country, and I applaud the members of this committee and the legislature for taking serious action to increase penalties for those who contribute to this crisis. Our officers, our department, and our association are in regular communication with law enforcement in neighboring cities and states who agree that tougher penalties for dealers are a huge step forward. We are also aware of legislation similar to LB 137 in state houses around the country and appreciate the tough and decisive message that Nebraska can send to those who knowingly deal and distribute a product that has killed and continue to kill hundreds of thousands of people. I urge the committee to advance LB 137, and I thank you for your time. I would like to just address one thing. One of the things in the homicide unit that we've come across with fentanyl, it's not mixed in an FDA lab. It's not made here in the states where every particle is accounted for. So when they do mix fentanyl in a foreign country where it comes in, they could throw a large batch in there and you could have a pill that has multiple grains of fentanyl in it, and you could have a pill that doesn't have any in it at all. So that's kind of where the lethality of it comes from, is one person, they may both get the same pill, but one has a bunch of fentanyl in it and the other one doesn't.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Next proponent. Welcome.
Good afternoon. My name is Linda Vermooten, Linda Vermooten. Now, I first want to thank Senator Geist for bringing forth this legislation. I speak from a little bit of a different perspective as a clinical mental health practitioner and a nurse, and having to work with individuals that have experienced a loss of a family member due to the use of a drug that they thought was just going to give them a little high for an evening of fun. I've worked with other individuals that are highly addicted now that didn't realize that this drug they were getting illegally was mixed and has caused a lot of harm physically, emotionally, and also financially, because they have to pick up the bill related to this. If we don't have severe penalties, these people are going to continue to come into our country and sell these drugs on our streets and harm our good citizens. We have to do all within our power to protect them from these. And looking through the bill, it sounds like a really good bill, and it will help our law enforcement make sure that when they capture them, there's a good chance of prosecution. So we don't have a revolving door that they go in and they come out. When you sit with these families and you hear their stories, it'll break your heart. I wish you could just spend an hour or two with me in my office to hear. They now have to live with consequences. Some family members have lost a teenager. Some family members have lost a child that was away at college. And now they are living with the devastation of this. There is an old phrase that we used to use, and that is, if you do the crime, you have to do the time, or you have to pay the penalty. But some of our crimes are so light on penalty, and I think it's good that we're strengthening our law enforcement to say there's a penalty, because if there's no deterrent, they're not going to stop. They don't care about the people they sell it to. They don't care about their families. So I'd really encourage you to advance this legislation. Thank you for your time, Senators.
Thank you. Any questions from the committee? Thank you for being here today. Next proponent. Next proponent. Next proponent. Welcome.
Thank you. Members of the Judicial Committee, thank you for allowing me the time to speak today and take the time to hear me out. 3 minutes isn't sufficient time to cover what I need to say, so I've attached a supplement for your copies. With your copies, I hope and pray you'll take the time to read it before casting your vote.
Can you state and spell your name?
Sure. My name is Adam Wiblishauser. My last name is Wiblishouser. I am the father of a 16-year-old son who was poisoned and killed last November 11th by a counterfeit pill. I will never see him again, and I will never be able to see what he would have become in life. The person responsible for supplying the poison will likely never be held accountable. I use the word poisoning because that's exactly what it is. A person unlawfully created a pill to look like another drug. In this case, AJ thought it was a Percocet, but instead the pill contained no Percocet but a lethal dose of fentanyl. To my knowledge, it is not common for a person to die from taking a single Percocet tablet. In fact, it's very unlikely. This is where I have a hard time wrapping my head around the law. If I was to serve my wife a glass of antifreeze and tell her it was Kool-Aid and she drank it and died, I would certainly be charged with murder. I would expect nothing less, but if I create a poison pill and sell it to another relatively harmless drug that ends up killing someone, I'm not guilty of a serious crime? How can this be? Where's the logic? Most importantly, where's the deterrence to a drug dealer? Since AJ's death, I've educated myself extensively on fentanyl and have learned that currently right here in Lincoln and Omaha, 8 out of 10 pills obtained illegally are counterfeit. From there, you're rolling the dice on what you're getting. Most likely it'll be fentanyl or some variation of it. These drugs are attractive to dealers because they are highly addictive. The high lasts for a shorter amount of time and leaves the buyer coming back for more and more, each time spinning the chamber in a literal game of Russian roulette. These pills are widely and easily accessible to anyone, even kids, on social media, most notably Snapchat, an app that takes great care to ensure parents can't monitor their teens' activities and is resistant to law enforcement. More times than not, these pills are exchanged from one person to another, neither of which know they contain fentanyl. For example, I buy on social media some pills that I believe to be oxycodone. They appear exactly as the description would appear in any drug manual. Not knowing, I share them with some friends. How many people are going to die that day from that one drug transaction? You can find everything that you need to set yourself up to make these pills on Amazon, spending only a couple $100. In making a pill, a 2 milligram dose of fentanyl is a potentially lethal dose. That's 2 millionths of a gram, about the size of a couple grains of salt. Now imagine these pills being produced in someone's kitchen or garage by someone who has no scientific training and likely does not have the knowledge or tools to properly measure a safe dosage. I'm sure they are not setting out to kill people, but if they do, whoops. Think about your sons, daughters, and grandchildren being thought of as collateral damage to some thug that make $20. They thought the pill might help them relax or get through the next exam at school. They are being poisoned. They are not getting what they believe they bought. And if this doesn't scare you, it should. In closing, I don't support LB 137 because I want to see or cause mass incarceration. In fact, I want to see quite the opposite. I want to arm local prosecutors and law enforcement with the tools they need to do their job and to serve as a concrete deterrent. On the same breath, if we're dealing with
time, sir, I'm pretty strict about it, but I got your testimony here and see if anybody will ask some questions. Any questions? Senator Ivey.
Thank you. You mentioned Snapchat in your testimony. Can you expand on how kids use Snapchat?
Yeah, absolutely. What I've learned really just recently is if someone like you or I sign up for Snapchat, what we're going to see is basically what looks like a teeny bopper app where you can go on there, make funny faces and put dog ears and stuff on your head and maybe chat with some of your friends. What these teens are seeing is completely different. Drug dealers can find them. They can locate and pinpoint their exact location. They can reach out to them and they're advertising drugs. So when they scroll and they're looking through their videos, they're seeing advertisements for drugs and how to contact a drug dealer if that drug dealer isn't contacting them. Snapchat's known about this for a very long time and has done little to nothing to stop it.
To monitor it. Is it probably the most popular social media site to engage in?
Snapchat boasts on its investor website under Snap Inc. that they reach 90% of persons aged 13 to 23 years old in 20 plus countries. That is where AJ most likely obtained the fentanyl, and from what I understand, that's where most of it's coming from, at least around here.
Thank you. Thank you, Mr. Chairman.
Any other? And thank you for the longer one. I'll definitely read it.
Thank you.
Any questions from the committee? Seeing it, thank you for being here today. Next, proponent. Welcome.
Thank you. Name is Robert Griffith, Griffith. I go by Michael. Thank you all for taking the time to listen to my testimony. Taryn was a beautiful young woman inside and out with her whole life ahead of her. With a 6-month baby girl starting a new job, finally she found the true meaning of life, along with the love of her life, her baby girl. Taryn was the type of person who made friends easily, enjoyed life, enjoyed being outdoors in the company of her friends. On November 30th, 2021, all that ended when someone offered her a counterfeit pill laced with enough fentanyl to kill 8 people. Besides the loss of our daughter, what makes this hard for us is we have the drug dealer's name, and the Lincoln Police Department also has video footage of this individual giving Taryn the pill. Yes, a lot of proof, but yet he will not be charged for the murder of my daughter under the state of Nebraska, because there is no law to protect Nebraskans from this deadly crisis. Synthetic opioids are truly a weapon of mass destruction, a violent crime that needs to be addressed in our state. Why do I say it's a violent crime? That night of Taryn's death, she was with a so-called friend. Instead of rendering help or calling 911, she had Taryn placed in the back room of the establishment they were at, took Snapchat pictures of her and posted it on the internet. I was able to obtain one of these pictures. And it shows my daughter clenching her chest, gasping for air, very similar to a strangulation, except it's a lot slower process, and she does not physically have the hands around her neck. It's cutting off her air supply. Society in general takes a look at these deaths as an overdose. We need to change the narrative and stop looking at these deaths as overdoses. When the majority is synthetic opioids should be treated as a poison, how can we continue to label these overdose when the victim, as in Taryn's case, was deceived and thinking they were taking a legit pill? Majorities who die from synthetic opioids know what they took. A counterfeit Percocet, an Adderall, or Xanax. They did not know that cocaine, marijuana, methamphetamine, drug of choice, was laced with fentanyl analogs. Analogs like carfentanil, which is 100 times more potent than fentanyl. And today, drug cartels are using drugs like xylene, amyl, which is an animal tranquilizer veterinarians use for large animals. The purpose of this drug is to extend the euphoria effect of the drug. This is a non-opioid, so Narcan has no effect in saving the life of the victim. Just recently, U.S. Drug Enforcement has issued a public safety alert warning Americans about the widespread threat of fentanyl mixed with xylene called trans or zombie drug, making this one of the most deadliest drugs in our country has ever faced.
Thank you for your testimony. Any questions? I have one. Do you have I know you have written testimony. Did you provide copies?
I have one copy. I didn't make 12, so but I do have one.
My question is,
right here.
Can we make copies? Is there
Yes,
anything
I can
you
make.
don't?
I can get copies.
They'll make copies for us. But I'm gonna ask you an open-ended question to give you time to wrap up your final thoughts. That's a question. I mean, you came down here. I want you to be heard. You came down here. You should get heard. But we are strict about 3 minutes. But I want you to wrap up your thoughts.
I have a lot more to say. You know, back in 2018, Nebraska State Patrol seized 120 pounds of fentanyl, just enough to kill 26 million Americans. That's enough to kill every Nebraskan 13 times over. That's a weapon of mass destruction. And how many Nebraskans need to die of this weapon of mass destruction before the state considers this to be an issue? How many more families need to be devastated and have their lives completely destroyed by these drug dealers, drug pill pushers that have no respect for life? Currently, there are 24 states that do have or 25, including the federal, that have a drug-induced homicide. And also South Carolina is also looking to pass a law this year.
I appreciate it, and you gave them a copyright. My question to you, though, would you want that to be a part of the record or just for the committee? Because you brought
Part of the record.
Okay, thank you. I just didn't want to, because y'all know we're just doing it kind of on the fly. I want to make sure your privacy is respected too. So we'll put that as part of the record as an exhibit, and we'll also make sure everybody has a copy of it. So thank you. Any questions from the committee? Seeing none, thank you for being here today.
Thank you.
Next, proponent. Proponent. Switching to opponents. Welcome.
Thank you. Good afternoon, members of the committee. My name is Spike Eichholt, S-P-I-K-E. Last name is spelled E-I-C-K-H-O-L-T. I'm appearing on behalf of the Nebraska Criminal Defense Attorneys Association in opposition to LB 137. Myself and one of our members did meet with Senator Geist a few weeks ago and discussed our concerns with the bill and explained what our opposition was. I know there are people here who have suffered a tremendous loss, and I don't want my opposition testimony to somehow be interpreted as dismissive of their loss. I know that's a trite thing for them to hear, but I want to say that. Mr. Condon mentioned this earlier when he was testifying as a proponent. I think it's inaccurate to say that there's nothing that can be done in state law to prosecute a death if a delivery of a controlled substance results in that death. We do have the crime of manslaughter, which can be proved if the state, if a person commits an unlawful act, and while commission of that act is happening, there's a death that results. In my handout, I referenced a 1981 Nebraska Supreme Court case in which a defendant was found guilty of delivery of controlled substance and manslaughter for providing his friend with a sleeping pill when they were both drinking and smoking marijuana. I actually saw Mr. Condon before he testified, and I attached to my statement a news article where I remember when I was in the public defender's office where Mr. Condon got a conviction for somebody who confessed to providing methamphetamine to someone who died of a drug overdose, and they were able to convict of manslaughter and delivery of a controlled substance. So I think it's inaccurate to say that nothing can be done to convict somebody of a homicide case, because there are cases that show that that is possible to do. Admittedly, this is a slightly different approach because you don't have to prove, or a prosecutor does not have to prove two crimes. They simply have to show the enhancement of the underlying crime of delivery. But I would submit, as Mr. Wayne or Senator Wayne asked earlier, the difficulty in proving a case, identifying the deliverer, identifying the controlled substance, is going to be the same thing that may be an obstacle right now to convicting somebody with manslaughter. And I don't know if that's going to change if this law is passed. Secondly, and Senator Geist mentioned this in her introduction, one concern that we have is that the bill criminalizes or provides for the enhancement of death or serious bodily injury. Our statute and case law defines similar serious bodily injury to include the risk of serious or permanent disfigurement or impairment of the function of a body. Arguably, any kind of use of fentanyl is a serious risk. And we would submit that if the committee is going to act on this, that perhaps it only apply to deliveries that result in actual death. Admittedly, this is similar to federal law, as you heard people say, and there's nothing stopping the state from mimicking the federal law and doing this so. The state did so in 2009. I've distributed an article from Henry Cordes where he summarizes that we can trace the growth in our prison population when we decided to match our state laws with the federal gun laws. And Senator Wayne mentioned that earlier, and that's one of the reasons we would urge caution in adopting this bill. And then I'll answer any questions if anyone has any.
Thank you. Any questions from the committee? Senator McKinney.
Thank you. Thank you, Spike. Has the war on drugs worked?
I would say we've not won it. I would say no. I mean, it's worked to a certain extent. It's helped incarcerate people. It's helped create a system of prosecution. It's worked, but I don't know that it's really resulted in discouraging the use of drugs.
Why not?
I mean, I don't know if I have all the answers. I mean, part of it is it's societal. Sometimes people use drugs as just to treat the general sort of malaise of just living in this world. It's just treatment that kind of people have for anxiety. It's treatment some people have for depression. People self-medicate using illegal drugs. It's marketed and pushed by industries to young people to use drugs. It's a cool thing for kids to do. There's just a whole culture of it. Sometimes addressing that could be done in a variety of different ways. We seem to have for years led on a carceral response. Get tough, increase penalties, provide for arrests, don't let people bond, provide for enhancements. And I don't think that method's worked. I think that some people in some countries have had more success with education, treatment. Some countries are experimenting with legalizing drugs, where you have an industry that regulates so you don't have the problem with imitation controlled substance, with people mixing things on their own. If you have it sort of legal, that's one way to approach it. So there's a variety of different ways, and I know it's just kind of rambling. So
Thank you. Look, I was late, but I was listening, and I heard a couple people mention the war on drugs and being tough, and it's not to diminish what's happened, because I think it's horrible. And I don't think anybody should be selling any type of fentanyl to anybody, because it's killed people that I know, that I grew up with, that I went to school with. But it just sparks a light in my brain going back to the war on drugs around the crack epidemic and how that was treated more so carceral and punitive versus treating addictions, treating the root causes to why individual would use drugs or sell drugs and those type of things. And I think that should be the war on drugs. It shouldn't always be let's increase penalties because we're going to scare these people, because in reality, we had the war on drugs and a crack epidemic, and people are still getting convicted and smoking crack every day. So I don't know if increasing penalties eliminates that reality.
I agree.
Thank you.
Any other questions? Senator Decay.
If the war on drugs isn't working, how do we prevent these tragedies from happening in the future if we don't try to enact some kind of bill so that somebody is held accountable if they're going for the $20 profit off of selling a fix or whatever? How do we combat that? Because education, things happen in the spur of the moment. Education's not always the best answer, because late at night things happen that education, not everybody's thinking in a clear mind. So how do we hold people accountable?
Well, I don't know that we're not holding people accountable now. As you heard, and I think some of the proponents acknowledge that these instances are charged by the federal government now. We do have state laws that apply. Delivery of a controlled substance, whether it results in injury or death to anybody, is at least, for the drugs we're talking about, at least 1 to 50 years imprisonment. If it's within a school zone, or if it's a certain minimum amount of at least 10 grams, it's a mandatory minimum 3, up to 5, up to 20 years to life imprisonment. It's fairly significant now. So I would respectfully say that we have criminal penalties now for what's going on.
That's for delivering the controlled drug?
Yes.
So where do we go with if we have if you want to call it a homicide that takes place or a death that takes place because of the delivery of these drugs? How should that penalty be enhanced further, or use the same?
It could be, and that's what the bill proposes. As I tried to explain, I was not very clear in my opposition testimony initially. We have the crime of manslaughter. One way you can prove manslaughter is if a death results in an unintentional act. It doesn't have to be intentional. There was a case that I cite in my letter from August 2022 where our Supreme Court upheld a manslaughter case because of a traffic infraction being the underlying unlawful act. So if the prosecutor and the cops can learn the identity of somebody, know that what they delivered to somebody resulted in their death, I would submit they can convict them with manslaughter now, in addition to the delivery of a controlled substance. Now, maybe it's difficult just factually to prove that whatever was given to this person ended up actually being ingested by that person, which ended up resulting in the death. That might be difficult to prove. I don't know if that's going to be any easier to prove with the bill. I think it's still going to be difficult, as I think the woman from the Omaha Police Department explained. Sometimes the federal governments
And
don't take cases.
I'm not in forensics or anything, but do blood, urine, tissue, hair follicles, or anything, can that help prove
It can't.
the drug that was ingested?
I think so, yes. The difficulty might just be simply if learning where it came from before it was ingested.
Senator DeBoer.
Under current law, if you were trying to charge someone with manslaughter and they sold the drug, but they thought it was whatever, cocaine,
Right.
but it was actually fentanyl, led to the death. But the person who sold it thought that it was cocaine. You couldn't get them they wouldn't have the requisite intent, would they?
For manslaughter?
Yeah.
You don't, for the manslaughter, if a death results during the commission of unlawful act, it's not an intentional crime. It's not
So
even
then
a
it doesn't
knowing crime.
matter, it's,
That's right. That's why the case that I cited from August last year was reckless driving or willful reckless driving, something like that. A person was driving recklessly and hit somebody walking on the side of the road. He said, I didn't see that person there.
so the intent
Didn't
is in the
intend.
underlying crime,
That's
not in
right.
the manslaughter.
And if you look at the article that I attached, Mr. Condon referenced earlier, they were able to get that manslaughter conviction because of the confession of the defendant in that case, where he admitted to injecting the methamphetamine, either in an amount too much, or I don't know if it was mixed with something else or what, but whatever he did resulted in the death.
Okay, thank you.
Now I have to go back and look at the, why wouldn't felony murder apply?
I don't think that's one of the underlying felonies. It has to be, I think there's 6 or 7 different felonies: robbery, burglary, sexual
right.
assault.
So wouldn't that
something
be
else.
an easier fix?
Well, that would make, could be, that would be then a first degree murder with life imprisonment on the table. And arguably, if you look at, which I don't necessarily.
That is the question you wanted me to ask.
That's not where I wanted to steer a discussion necessarily. But if you look at 28303 sub 3, that's the current first degree murder
Right.
statute. It does provide for prosecution if you intentionally, with premeditation, poison someone,
Right.
That's the,
which you can do.
But you have to have intentional, that's the issue.
That's right.
Okay.
That wouldn't support a murder conviction, but would support, if it's something illegal, manslaughter conviction.
Okay. I think what you're seeing here is everybody's recognizing the issue of fentanyl or trying to figure out how to get there. Any other questions from the committee? Senator McKinney. Senator McKinney.
What if I'm with my friend? I'm not selling to him. We're just together, and I have some pills that I think are Percocets. I give my friend a Percocet. My friend passes away. What is that?
Well, if they can prove that, that's delivery of a controlled substance, because Percocet is a controlled substance. Presumably, you're not a pharmacist, and that person doesn't have, your friend does not have a prescription. So that's delivery. Results in death, and they can show that what you gave them resulted in that person's death. I think that would also be manslaughter. That's the unlawful act, and during the commission of that unlawful act, death results.
All right, thank you.
Any other questions? Seeing none, thank you for being here. Any other opponents? Anybody here testifying in a neutral capacity? Neutral capacity. As Senator Geist comes up to close, we have 2 letters for the record, and both of those are in support. Welcome back, Senator Geist.
Thank you. Whew, this is a tough one. I am passing out a letter from the Omaha Sheriff's Department in support. But besides that, part of my intention here isn't to spread wide incarceration. It's not to spread the net wide. It's actually, because it is difficult to prosecute some of these cases, is sort of the guardrail that I wanted to use to make sure we're not just mass incarcerating. But I do believe that it's justice for those who do this kind of crime. And the perception of the people that end up being victims here is not necessarily someone addicted to drugs, and not necessarily someone with an addiction problem, but someone who's taking something that they don't know is laced with fentanyl, which only takes 2 milligrams, as you heard earlier, to be lethal. And that's like a few grains of salt. So it's so tiny. It's so different from other opioids in that sense, where other in weight, we just can't compare it to the other opioids because it's so much more potent. And I don't want this time to go by without me thanking the families who were here, who had the courage to show up today to tell their story. I'm glad that you got the handouts. I would encourage you to read their stories. They've been through a lot, and this is because I'm acknowledging what they've been through. The reason that I brought this bill and the reason that we didn't choose manslaughter is because it is a lower penalty, and I did intend to have a higher penalty. I know that that's an option that could be used. That can range from probation to 20 years, which actually with good time is 10. You get parole way before that. So I did intend to make a 2A felony or up to that. A judge would have the discretion to go lower than that. But a 1B felony, which is what we've raised this enhancement to be, is 20 to life. So the judge would have discretion within that and understand that with good time, that means 10 to whatever the top number the judge decided. And that would be given what the severity of the crime is under the discretion of the judge. But I believe if I were sitting out here and I was one of these family members, it doesn't change what they've been through, but it does give a sense of justice, I believe, to what they've been through. With that, I would take any questions that you would have.
Any questions from the committee? I have a lot more questions, but we can talk about it.
Okay.
I'm trying to think through it, but
Okay,
in the essence of time,
I'd be happy.
I think we're on the same page. We got to figure out
Yeah.
how to get there. Any other questions? Seeing none.
Thank you.
Close the hearing on LB 137. And we'll open the hearing. For those watching at home, we now start the Senator McDonnell show.
One bill.
We're gonna do a joint hearing on all 75 bills in front of us. No, we'll start the hearing on LB 106 and 107. For those who are here to testify, please listen up. We are using the 3-minute light system, but I recognize that you probably are here on both bills. So I am gonna let it go a little over, but I'm gonna try to keep it still around 3 minutes, but I won't be as strict with cutting people off, but I will not let it go over 4. And so we will try to maintain kind of the timeline. Thank you. With that, you may open, Senator McDonnell.
Thank you, Chairperson Wayne and members of the committee. And also thank you for allowing me to combine LB 106 and LB 107 today with this hearing. My name is Mike McDonnell, McDonnell. I represent Legislative District 5, South Omaha. I'm here today to present LB 106 with Amendment 917, which is currently being handed out, and LB 107, 2 bills that aim to address the rising rates of digital exploitation and enticement and sexual abuse stemming from digital grooming of vulnerable adults and minors. LB 106 creates the offense of digital grooming of a vulnerable adult and prohibits the use of electronic communication devices on social media to engage in certain conduct with vulnerable adults. LB 107, on the other hand, addresses the digital exploitation, enticement, and sexual abuse of minors through the creation of the offense of digital grooming of a minor. Both bills build on current laws outlining the procurement and sharing of child sex abuse materials and aim to create tools for earlier intervention in the digital grooming process. Our current laws surrounding digital grooming, digital enticement, were last updated in 2009, leaving room for gaps and many Nebraskans to go unsupported and unprotected. As our digital world has adapted and changed over the years, our laws have stayed stagnant. I apologize. Sorry. As our digital world has adapted and changed over the years, our laws have stayed stagnant, leaving vulnerable adults and minors at risk. These bills strengthen current statutes to close those gaps and enable law enforcement to intervene earlier in the grooming process before sexual violence or exploitation occurs, resulting in less trauma for the intended victims and lower criminal burden for the offenders. Today, you will hear from proponents, from law enforcement advocates for digital safety, behavioral health, and disability rights, as well as individuals who have lived the experience with digital grooming. I urge you to support LB 106 and Amendment 917, LB 107, and join the Amendment 917, and join the fight against digital exploitation of vulnerable adults and minors in our state. Here to answer your questions, I'll be here to close. Again, there is a number of people that came, and I appreciate them here, being here to testify and tell their story.
Any questions from the committee? Seeing none?
Thank you.
You didn't break the rules. I'm going to have to add to the rules. Please silence your watch too. So I'll take care of that.
I left my phone over there. I brought my watch. I'll leave my watch back there.
Thank you. Will you be here? Oh, you'll be here for close. Never mind.
I'll be here.
Yeah.
As you mentioned, I'll be here all day.
Okay. First proponent.
Good afternoon. My name is Amy Konwinski, AMIE-KONWINSKI. I am here today as a digital use expert and the founder and CEO of SmartGen Society, an Omaha-based national nonprofit working to protect digital users' rights for safety and privacy in all digital spaces, including social media and interactive gaming. SmartGen Society, along with our community partners, have spent the past 2.5 years researching and developing anti-digital grooming legislation, known today as LB 106 and 107. We bring you this vital legislation to update current Nebraska laws to reflect modern-day technology integration, strengthen current statutes, fill holes for protection in digital spaces, and safeguard against sexual violence against minors and vulnerable adults. Digital grooming is the use of a digital device or social media platform to establish an emotional connection with a vulnerable adult or child with the intent of abuse or exploitation. Grooming is intent to abuse, and grooming speech is categorized as solicitation speech and therefore unprotected under the U.S. Constitution. Imagine your 13-year-old son or daughter receiving this message in their direct messages. Hello, beautiful, heart emoji. I find you very attractive, and I'd just like you to be my sugar baby. I can give you a weekly allowance and send you gifts, just basically paying for your time and spoiling you. This message was received by my minor daughter. In Nebraska, between 50 and 70% of students surveyed reported receiving offers of financial gain in exchange for connecting with strangers online. The easy accessibility to children in digital spaces has never been as simple as it is today, with 56% of 5-year-olds now having their own digital device, and the average age to receive a smartphone is just 10.3. Predators online have become emboldened by the easy accessibility to literally millions of minors known through social media and accessibility to alarming rates of child sexual abuse material. This accessibility extends to all hours of the day and night, with 85% of Nebraskan minors surveyed reporting keeping their smart devices in their rooms at night. It takes on average less than 10 minutes for an online predator to make a conversation sexualized and to ask for nude images. For law enforcement, unless images received meets the threshold of child pornography, being pictures of genitals, anus, or sexual acts, officers are unable to intervene and grooming process and have to wait till greater harm has been perpetrated on the victim. Under current laws, digital predators are aware of how far they can push the conversation and request images cataloged as child erotica, including images of breasts, buttocks, bellies, and feet, which do not fall under child pornography, but is sexually gratifying for the predator. For victims of digital grooming, the loss of innocence, vacant expressions, and persistent fear of who has seen my images remains a relentless presence in their lives for years. This committee can make a priority to protect minors and vulnerable adults in digital spaces, and we ask you to vote yes to move these bills onto the floor. Thank you, and I'd be happy to take your questions.
Any questions for Senator Holcroft?
Yes, thank you, Chairman Wayne. I believe your organization has a program that goes out to schools. Is that correct?
That is correct.
Can you tell us more about that, please?
Yes, we offer proactive education to make sure students are their own first lines of self-defense. We talk with students, parents, and educators on making sure they know how to be safe, private, and on brand on their digital spaces. So far in the short of 7 years, we've spoken to over 70,000 students and parents in 16 states.
Thank you.
Any other questions? Seeing none, thank you for being here.
Thank you.
Next, proponent. Welcome.
Good afternoon. My name is Grace Corrigan, GRACECORRIGAN. LB 106 and LB 107 may just seem like numbers on a piece of paper, but to me it is so much more than that. Adults are people that we as kids should be able to look up to. Adults should be role models and people we can trust to look out for us and have our best interests at heart. Unfortunately, this is not the case for many kids, and this was certainly not the case for me. One of the most important adults to young athletes are their coaches. Kids put so much trust in their coaches in guiding them and help them excel at their sport. They have dreams that they know their coach will help them achieve. I trusted my soccer coach with everything in me and put my athletic career in his hands. I felt that I could go to him for anything and everything, but what I didn't know was that the whole time he was abusing the relationship. I was taken advantage of, and I didn't realize what was happening. I was 13 years old and I was terrified. It is now unimaginable to me how easily this happened. If it can happen to me, it can happen to anyone. His process of luring me and using Snapchat to communicate was his way of getting closer to me. He was grooming me for something more. I spent countless sleepless nights crying and thinking I was stupid. How could I have not caught this and realized how wrong it was for the coach I trusted to abuse our relationship? I was captain of his team, and he knew of my goal to play college soccer. He would often make comments about my body and start calling me his hot, sexy favorite. He told me not to tell anyone because he knew it was wrong. I kept quiet because I was afraid. Things continued to get worse. He would talk about my body and he would ask for me to send him pictures. His comments started to become sexual in nature, and he would tell me how much he loved me. Luckily, one of my friends reported it and we got the police involved. Unfortunately, because this was all through Snapchat, most of the evidence was gone. The kissy faces, the sexual comments, the harassment vanished like it never happened. He knew what he was doing. Gratefully, during his questioning, he admitted he had sexual intentions with me. This statement ultimately led him to prison. What would happen if he never said these words? I'm 16 now. Would he have taken this a step further? These thoughts are constantly at the back of my mind. There would have been nothing to stop him. He would continue on with these behaviors. I'm here today to not only share my story, but to advocate for those who were never heard. After my story came out, it was unreal to me how many others could relate. Hearing their stories, knowing that I was not the only one, made me realize this needs to be stopped. Predators are taking advantage of modern technology. They know they can get away with it. There weren't many laws to protect me online when I was 13. Now, 3 years later, imagine how many more stories, how many more girls have been affected. Still nothing to protect us. Please vote for LB 106 and LB 107. Help protect your children. It's getting worse day by day. End digital grooming now before it affects your own family. Thank you for your time.
Thank you. Any questions from the committee? Seeing none, thank you for being here today. Next proponent.
Good afternoon. My name is Katie Thompson, KatieThompson. I'm here to support LB 106 and LB 107. I do not represent an organization. Today I'm here as a parent. I stand before you as a voice for my daughter, a voice for my 6 children, and a voice for those who were never heard. Even at a young age, Grace loved the game of soccer. At 13, it was clear she had a talent for the game as well. Her dream was to play college soccer. That year, she tried out for a name team. The coach of this team trained many female athletes who went on to play at a collegiate level. What a perfect opportunity for Grace. Coach was a man who loved the game of soccer and wanted to help young female athletes achieve their dreams. We trusted him. Grace trusted him. Unfortunately, our perception was completely wrong. He had other intentions with my 13-year-old daughter, and coaching soccer was not one of them. I was sitting on my front porch enjoying the beautiful weather on the evening I received the phone call. The photos are of your daughter. Those are the only words I remember hearing. Why did Coach have countless pictures of Grace on his phone? So many questions ran through my head, but what came to follow was something I would never be prepared for. In the few Snapchats that Grace saved, Coach referred to her as his hot, sexy favorite. He told her that he loved her and not to tell anyone. He told her he wished he was the popsicle she was sucking on. and according to our laws, he did nothing wrong. After the arrest, Coach admitted he had sexual intentions with Grace. It was only because of this statement he will spend the next 5 to 8 years in prison. I can't bear to think of what would have happened if he did not self-incriminate that day. His messages would have continued. How far would he have gone? Who would be his next victim? We all know that our laws have not caught up with the fast-changing digital world. According to the National Center for Missing and Exploited Children, online enticement saw a 97.5% rise in 2020. Additionally, we have seen numerous examples of what digital grooming can lead to. How many more stories does there need to be? I never thought this would have happened to my daughter, but the truth is, it can happen to anyone. What if the girl in the photo was your own daughter? Would you support this bill if the story was about your grandchild? Can you sleep at night knowing that you voted against a bill that would protect her or protect him? Thank you for letting me share my story. My daughter is not a victim. She is an advocate. And today we stand together to protect children across the state, including yours.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next pro forma.
Good afternoon. I am Russell Cook, RUSSELL-COOK. I am a detective with the Blair Police Department. I've been in law enforcement for 25 years, with 15 of those as a detective. I strongly support the proposed statutes to criminalize the digital grooming of minors and vulnerable adults for the prevention of sexual abuse and exploitation. Currently, the laws that attempt to address the type of behavior within Nebraska state statutes and the criminal child enticement law and enticement by electronic communication. Criminal child enticement has established that adults who attempt to normally solicit, coax, entice, or lure a child under the age of 14 into any vehicle or any place with the intent to seclude the child from his or her parent, guardian, or other legal custodian or the general public. Enticement by electronic communication establishes that if an adult knowingly and intentionally utilizes an electronic communication device to contact a child under the age of 16 by transmitting indecent, lewd, lascivious, or obscene language, writing, or sound, or disseminates any visual depiction of sexually explicit conduct. Both of these offenses have been classified as felonies. What these laws don't address is contact between an adult and a minor that would manipulate the minor into sexual contact. I have investigated instances where an adult has had contact with a minor through either school or school function or even places of employment. When these predators contact the juvenile, they begin to manipulate them with the goal of future sexual contact. In some of these cases, the predator has not sent obscene language or photos to the victim, or even tried to lure or separate them from their parents or guardian. But the goal is the same: sexual contact. Predators contact juveniles through social media and they begin a chat. The chat between them seems unthreatening and attempts to establish a personal relationship with the juvenile. Once the predator establishes the relationship, the chance of the juvenile becoming a victim is greatly increased. If law enforcement receives notice of this activity, the current law does not allow for any type of enforcement for this behavior. To clarify, adults may have contact with the juvenile even through social media outlets that are not predatory in nature. An example might be a relative, a school official, or a family friend having a conversation with the juvenile. When this becomes overtly sexual or the adult makes some mundane things explicit, they have victimized the child. Currently, there is no evidence that pedophilia can be cured. Therefore, the chance of recidivism in these types of crimes are greater than others. The safety of our children is paramount to our society, and I feel that the sex offender registry should be a part of the law for these reasons. I strongly support the safety of the children. Thank you for your consideration.
Any questions, Senator Decay?
Thank you. maybe I should have asked somebody before or somebody after you, but I'm asking you, what's the difference between a class 3A felony and a class 4 felony? The difference in these two?
I don't really have the answer for that, Senator. Some of the difference in the penalties.
I will ask somebody, but just so it's going forward, I want to have that question.
Thank you.
Any other questions? Seeing none, thank you for being here.
Thank you.
Next proponent. Welcome.
Thank you. Good afternoon, Senator and the rest of the committee. My name is Julia Hevenstreit, JuliaHevenstreit, and I'm here today to testify in support of LB 106 and 107 on behalf of the Kim Foundation and the Nebraska Association for Behavioral Health Organizations, otherwise known as NABHO. We all use technology every day. It has benefited our lives in a number of ways. However, as time has evolved, we have seen technology be used in ways that can have a very detrimental effect on our youth and vulnerable adults. LB 106 and 107 will help negate some of these negative effects. The Kim Foundation's mission is to serve as a supportive resource and compassionate voice for lives touched by mental illness and suicide. Our vision is a community free of suicide that embraces the importance of quality mental health care and services and prevention. We know through research and everyday practice that technology has detrimentally impacted the mental health of many community members and sadly led to suicide deaths in some cases. The Kim Foundation partners with the Omaha Police Department, Sarpy County Sheriff's, and Douglas County Sheriff's Office on a multi-pronged approach to suicide pre- and post-prevention in our community. The relevant component of this partnership here is that we receive every report on any suicide-related death, and we use these reports to collect data that can be used comparatively around gender, age, zip code, and method of death. We also often receive narrative information from law enforcement that contains more context to the situation surrounding the death. We don't have exact comparative data on the percentage of deaths that had some component that involved technology or social media, but I've been leading this effort since 2015, and I can tell you over the last 7+ years, there's been several cases where this has been, unfortunately, a component of the death. 7 other states have already passed similar legislation to these bills, and passing LB 106 and 107 will allow for Nebraska to join these states and lead the way in keeping our youth and vulnerable adult population safe from the harm of online grooming and sexual predators. Passing these bills will also allow us to evolve our statutory law to the current times around modern day technology integration. We know that the trauma many survivors of crimes such as these face can lead to years of PTSD and other mental health conditions. We can help to eliminate those struggles for many and possibly even save a life from suicide by intervening earlier, deterring offenders by strengthening statutes, and preventing potential sexual abuse and online extortion. NABHO and the Kim Foundation support LB 106 and 107 because they promote sound policy that keep our youth and vulnerable adults safe from predators by providing them the safe online space they deserve. We encourage each of you to vote in favor of passing LB 106 and 107 out of committee. And I just want to thank you today, and I'm happy to take any questions.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent.
Hello. Good afternoon, Senator Wayne and members of the Judicial Committee. My name is Denise Geringer, DeniseGehernger. I'm the Executive Director of Sheltering Tree, which builds and operates affordable apartments for adults with developmental disabilities in the Metro Omaha area. I'm also the President of the Down Syndrome Alliance of the Midlands and am involved with several disability organizations, both statewide and nationally. My most important role, however, is the mom to my 27-year-old son with Down syndrome. Because of all of these roles, I bring to the table lived experience supporting adults with developmental disabilities, and I know firsthand how technology has elevated their lives and at the same time put them in danger. The advancements in technology have been very empowering for adults with developmental disabilities. In addition to offering them tools and applications to navigate their world independently, sometimes even filling the gap in costly disability support services, it has also provided them access to social connections that are most missing in their lives. This access also opens the door for predators who seek to groom, manipulate, and exploit vulnerable adults into easy prey. This legislation, LB 106 and LB 107, is desperately needed so that an effective deterrent can be leveraged to put a halt to online digital grooming. Stopping the grooming before it results in a crime will prevent long-term effects and trauma that further burden the lives of vulnerable adults. These two bills update current laws that are outdated and bring them up to speed with modern-day technology. Let me share with you a story of an adult with developmental disabilities who was targeted, easily manipulated, and whose life was greatly impacted by the online predator. This adult, who has a developmental disability, lived independently in his own apartment, using technology as some of his main supports. As is typical with many vulnerable adults, loneliness leads them to unknowingly connect with the predator online. The predator slowly and methodically worked to gain the trust of the vulnerable adult and worked to emotionally connect them to the predator. This predator convinced the vulnerable adult to sell his possessions and put the proceeds of those sales on a Visa gift cards, which were then gifted to the predator. This predator even had the audacity to convince the vulnerable adult to attempt to change his automatic payroll deposit to the predator's account. Because of a good Samaritan in the HR department, this transaction was not made. When this grooming was finally discovered, the guardians of the vulnerable adult alerted both law enforcement and the Adult Protective Service. Because no crime was committed, nothing could be done, and the predator was left to go on to target others. And he did continue to attempt to connect with this vulnerable adult to further manipulate them. This vulnerable adult's life was dramatically changed. Their independence has been lost, and now they are significantly more isolated. They now have the added burden of this trauma and require more support than they did prior to this grooming. Thankfully, this grooming situation did not result in physical harm, but it could have very easily gone in that direction, as it has in many similar cases, resulting in sexual exploitation and physical assault. I'm asking you to see the importance of bringing current laws up to date, move LB 106 and 107 to general file, to put a halt to the targeting of children, vulnerable adult citizens online in Nebraska. It's the responsible thing to do. And with that, I'm happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here. Next proponent. Next proponent. Welcome back.
Thank you, Senator. Good afternoon, Senators and Committee. Thank you for the time to speak to you today. I'm Dr. Linda Vermooten, Linda Vermooten. You've heard some of the bravest people testify before you today, sharing their stories and the stories of their family. These are some of what I call my heroes. I have more than 26 years of experience in clinical practice with a postmaster's in marriage and family, doctorate in clinical psychology. My specialty is working with child and sexual abuse and rape. That's a heavy load to carry, but someone has to come alongside these people and help them pick up the pieces. As I look around us today, we see this old building. I've had the privilege of going up to one of the senator's offices up on the top floor. And I see all the paint peeling off the walls and the age. And as I look at our laws, I think some of our laws reflect our building. They are old, they are out of date, and they haven't stayed up with the current times. So I want to thank Senator McDonnell for bringing this legislation forward, because children are our most vulnerable. And vulnerable adults are right here along with them. They are susceptible. We teach our children to trust. We don't want to teach our children to be fearful of everyone around them, so we teach them to be selectively trusting. These people come online and pretend to be their friend and befriend them. Or it's somebody that they know, as we heard the testimony of today from one of the former testifiers, a coach, a parent, an uncle, a babysitter, a grandparent, a stranger. These are all stories of individuals that have sat with me, that I've had the privilege of working with. Their lives are devastated. They are left to pick up the pieces. It takes a huge amount of courage to face that. What now with these explicit photos that have been posted out on the web? They have no control over it. They can never get them back. The shame, the anger, the pain. So many of these individuals are highly suicidal because they feel like they can't go on with their life. They can't pick up the pieces They are no longer a person, but they are a thing, because they have been systematically groomed by someone for their own pleasure. As we have heard, 7 states have already advanced bills along these lines. I would ask, as we look at this bill, that we do not be one of the last states. So often Nebraska, our great state, is last in enacting legislation. When you have someone who is intentional about grooming somebody, they are very systematic. They have a plan and they are smart. They know how to sidestep through some of the loops that currently exist. And I believe this law will help tighten some of those loops and hold them accountable. Because if they know that there is accountability, the last place they want to land is in prison. Because there is a reputation of what will happen to somebody that abuses a child or vulnerable person in prison. So that deters them if they know that they get caught. I would strongly urge that we pass this bill forward to the legislature for a debate and a vote. Thank you so much for your time.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next, proponent. Proponent. Welcome.
Thank you, and good afternoon. My name is Hannah Vancat, HANNAHVANKAT, and I am here representing Nebraska Department of Health and Human Services, Boys Town, Lutheran Family Services, Nebraska State Soccer Association, and Respect. These organizations were not able to be physically present today, but have submitted letters of support and would like to be considered proponents of LB 106 and LB 107. Attached to this testimony are the letters of support submitted as exhibits. I am happy to answer any questions I am able to, or can follow up with any of the listed organizations to get answers to questions I may not know today. Thank you for your time and consideration, and on behalf of these organizations, we would love to see you all vote yes to moving these bills to the floor for further consideration.
Any questions from the committee? Thank you for being here. Any other proponents? Proponents. Proponents. Any opponents? Opponents.
Wait, I got. I think this is. Sorry. Sorry, it's my first time here. This is 107. This is 106. Sorry, I've got 2 handouts. I didn't realize the bills are going to be combined. My name is Spike Eichel, S-P-I-K-E. Last name is E-I-C-K-H-O-L-T. I'm appearing on behalf of the Nebraska Criminal Defense Attorneys Association in opposition to both of the bills. You've got my written testimony for both bills. I'll try to summarize the sort of bigger points for both bills. First, on LB 106, we would submit that existing law does provide sanctions for some of the conduct the bill is intended to target. I did meet with or visit with some of the people from Smart Gen Society last fall. They did reach out to me, and to their credit, they did hear me out from our association's concerns that we would have with the bills that they were planning on bringing. And I did raise some of the points with them, and to their credit, they did incorporate some of the things that I did point out. So in some respects, it made these bills perhaps a little more narrow. But on both of the bills, we would submit that much of the conduct they described here today, that they talked about, is already criminalized. If you look at my letter on LB 106, I list some of the specific crimes that apply. One point on LB 106, the venue provision is unnecessary, and I've stapled a statute that Senator Geist actually passed a couple of years ago that provided for a venue when you use electronic communication device in any sort of crime. So putting it in the body of a statute as an element of crime is just problematic and really unnecessary. On LB 107, where most of the testimony has been, we already have a number of crimes relating to online enticement. It's not called grooming or digital grooming or anything like that, but it's called online enticement, enticement by a child by electronic communication device. They have pretty serious felonies already. I've only attached one of those statutes because there's so many of them to my letter, but I would submit that this, not only is this proposal in LB 107 unnecessary, but it's going to recriminalize existing criminal conduct. It's going to provide for a lesser penalty than currently exists in the law, which is going to cause some confusion. And it's even more confusing for purposes of double jeopardy, lesser included offenses, and that sort of thing. If you look at the attached statute 28-320.02, and you look at sexual assault, use of electronic communication device, no person shall knowingly solicit, coax, entice, or lure any child 16 years of age or younger, or a police officer pretending to be such a child, by means of electronic communication device. And then they reference a whole series of different crimes that if a person uses electronic communication device to commit, they're going to be prosecuted. One of the crimes listed is the very crime this bill amends. So it's just sort of circular in how this is going to be prosecuted. Violation of this current existing law is punishable as a 1D felony, which is a mandatory minimum of 3 to 50 years imprisonment. The bill proposes to make it a class 4 felony, which is 0 to 2 years imprisonment. To answer your question, Senator Decay, a class 3A felony is 0 to 3 years imprisonment, up to a $10,000 fine, and 9 to 18 months post-release supervision. I thought it was a little bit frustrating that some of the proponents are arguing the penalties are not severe enough, and they don't even know what the penalties are proposed in the bill. And if anything, there are lesser penalties than have right now, which you might think, well, why wouldn't we support it then? And, we practice in this area. This is bringing uncertainty, I would submit, to something that's certainty. These convictions are common. People said the people know what the law are now. We got to catch the perpetrators. There was a recent case just 3 days ago where an Omaha police officer was caught up in this thing. There's a retired or former state trooper who was also similarly prosecuted under existing law. If law enforcement can't somehow beat the system, I don't think that people are that sophisticated. I'll answer any questions if you have any.
Any questions from the committee? Senator DeBoer.
So you mentioned the uncertainty to certainty. Can you elaborate on that concept?
Well, if you look at the, I'm talking about LB 107 primarily. If you look at the statute that I stapled on there, you can see how some crimes can be prosecuted. But if you look at what LB 107 proposes, they create this crime called offensive digital grooming. If they are 19 years of age or older, and they knowingly and intentionally use an electronic communication device or social media, and I don't quite know how you do that outside of an electronic communication device, to communicate with child 16 years of age or under with the intent to, and then it lists 3 different general ways you can do it. The sub 1 that's on page 2 of LB 107, lines 21 through 22, engage in sexual contact or sexual penetration. That arguably is already criminalized in 320.02. But the part that's not criminalized is this catch-all, regardless of when in the child life the actual sexual contact or sexual penetration would take place. That's new, and that's problematic. For instance, you could have a 19-year-old senior texting a 15-year-old freshman or middle school girl, asking her out, saying, I like you, you're attractive. Nothing happens until she turns 16 a couple years later. They're intimate. The crime's been committed then, according to this bill's proposal, because it doesn't matter when the sexual contact or sexual penetration takes place. The second part is the sub 2, which I think is also confusing, is lines 23 to 24, receive a visual depiction of the child for purposes of sexual gratification.
So here's the question with how, these are intentions that we're trying to prove, right?
That's right.
So how do we prove these intentions? I mean, if I'm a prosecutor and I'm trying to, I wish there had been a prosecutor here. Usually you can't throw a dead cat without finding a prosecutor in here. I don't know where they are when we need them.
Oh, this is enhancement. They all support this.
Oh, well, I wish we had one because I would like to ask how you would prove this and if this is going to be something that they can show the intent to, how do you show intent to receive a visual depiction for purposes of sexual gratification?
Well, I'll take my stab at it if you're asking.
Yeah.
Because if you look, it says a visual depiction of the child. if you look at our current child pornography statutes, if you have anything that depicts a child's genitalia, maybe in a sexual position or whatever, it doesn't matter. You have it, you're in trouble. It doesn't matter why you had it, what you
Right.
intended or knowing, whatever. This requires not only the proof of knowingly and intentionally, but it simply says any depiction that's not necessarily sexualized in and of itself. So I don't know how you prove that. It's very subjective unless somebody confesses to it all. If they do, they've confessed a whole bunch of other crimes already.
So if we pass this, whatever, and I've got, as a prosecutor, I've got this one sitting out there, but I'm gonna do it under the old ones because they're obviously easier to prove. Does this one affect, I just don't know. I haven't
Well,
practiced, I mean.
One way it could affect, and perhaps I shouldn't share it, but if I'm defending somebody who's charged under the old statute, this new statute passes. If the facts are right, I might ask for a lesser included offense for this, asking that the jury be instructed that you can find the defendant guilty of the big original crime, or if you don't think somehow they committed that, you may find them guilty of this lesser newer crime. They won't explain it that way. I'm certainly going to want it. I'm certainly going to argue for it because it exposes my guy from a mandatory minimum of 3 to 50 to 0 to 2 years, which I have to confess is not necessarily
I don't think this is the intention of the
No.
folks who wrote this bill.
no.
I think it's the opposite of the intention of the folks who wrote this bill.
I think you're probably right.
Okay, thanks.
Any other questions from the committee? Seeing none, thank you for being here. Next opponent. Welcome.
My name is Jeannie Mezger, Jeaniemezger. I advocate for people who are on the sex offense registry and for their families. A name on the registry always affects more than that one person. It affects spouses and children, parents and siblings. It can isolate the whole family and keep them mired in poverty by keeping the registrant unemployed or underemployed. As a mother, I'm sympathetic to parents who wonder what awful stuff might be happening on a child's phone. And I hope we can all agree that prevention ought to be our goal. Let's find ways to block paths that lead to molestation. Prevention would mean fewer people suffering as a victim of a sex crime, and it would also mean that fewer people are added to the sex offense registry. When I first heard about this legislation, I was told that it was intended to be preventive, to stop the grooming before any molestation or assaults happened. The story used to show how bad grooming can be and why this bill is needed was about the Gretna soccer coach who sent sexually explicit texts to one of his players. That coach is now doing 5 to 8 years in prison on a conviction for child enticement using an electronic communication device. So it seems that there already is a charge for that situation. Effective prevention measures would include a way for someone to ask for and get help before anything illegal happens. Prevention would mean educating adults and minors about how to shut down inappropriate social media conversations. It would mean a way to report and deal with early signs of a questionable text without the stigma that shames people into not asking for help. This bill does nothing preventive. What it would do is put somebody on the sex offense registry, and I'm always opposed to that. The next arrest for a sex offense in your community is most likely to be of someone not on the registry, and quite possibly of someone who's a trusted member of the community. Listing even more people is not a preventive measure. It's easier to punish someone after harm is done, but it's far better to prevent the harm. I urge you to vote against this bill. Thank you. Do you have any questions?
Any questions from the committee? Seeing none, thank you for being here. Next opponent. Anybody testifying in neutral capacity?
I'm almost never neutral. This is new for me.
Chairperson Wayne, members of the Judiciary Committee, my name is Erin Feichtinger, ERINFEICHTINGER, and I am the Policy Director for the Women's Fund of Omaha. We believe in doing all we can to prevent and end sexual assault and sex trafficking. We are not opposed to the intention of these bills, and we wanted to take the opportunity to highlight just some of the concerns we have with the timing and approach of these bills in our current political climate. Grooming has a very specific definition in the context of child sexual abuse and trafficking, which these bills do take into account. However, this term has been used both nationally and very recently in this state in very harmful and damaging ways against the LGBTQ+ community, as well as against advocates such as ourselves, for those advocating for teaching comprehensive sex education. The goal of this legislation is to prevent child sexual abuse, and that is a noble goal. And it does not happen by just providing new criminal penalties while at the same time introducing bills that would restrict the ability of youth to empower and protect themselves from abuse. Research suggests that one of the most effective tools to reduce child sexual abuse and trafficking is to provide age-appropriate comprehensive health education, including for young children, which is precisely what has been labeled as grooming across the country. We could do both. We would support doing both, but we are not doing both right now. We have some concerns given the current heated political climate here in Nebraska around both comprehensive sex education and the LGBTQ+ community, that those who provide resources for either could later be subject to investigation if not the penalties provided for in these bills. Exactly that question of intention that you had brought up earlier, Senator DeBoer. Discouraging age-appropriate sex education, as well as misinformed and misapplied rhetoric that confuses the public's understanding about what grooming actually is in this context, could ultimately harm legitimate efforts to prevent child sexual abuse and trafficking. Once again, we are not opposed to the intentions of these bills, nor obviously the effort to end child sexual abuse and trafficking, which is why we have consistently followed research and evidence-based practices, such as supporting access to comprehensive health education. We have been called groomers as a result. We continue to support efforts to end child sexual abuse and trafficking. If this committee chooses to advance LB 106 and 107, we would encourage monitoring how grooming is defined and applied as it is implemented, and to be mindful how this statute could be manipulated later down the road. We also encourage continued efforts to empower young people with the tools and information they need to make healthy choices both on and offline. And I'm happy to answer any questions to the best of my ability.
Senator DeKay.
Thank you. Is there a different title we could use so that we can differentiate between the two sectors that you were talking about, so the intent of these bills would not lost with the events that led to this point now?
Yeah, I think that's a great question. It's certainly the term, and again, these bills taken to apply the appropriate use of the word grooming and what that means in this context. We would also just be a little concerned about establishing, trying to prove intention makes it a little difficult. Like if a student is, let's say, asking a question of Planned Parenthood, could the person on the other side of that providing, information about sex or birth control, could they be put under investigation for intending to provide sexual materials? You have a bill tomorrow in this committee that is going to further define obscenity statutes and could put other folks at risk too. So I think it's a great question, and I think it's one, again, that we can keep working on together. I know that was a roundabout way of answering your question, and I apologize, Senator.
Not a problem. With these bills coming forward for me, I want to be able to understand that we can get to the point that these kids,
right,
being victims that they are, these things, the people that perpetrated these crimes are handled in the appropriate manner. So, and if we got to change titles or whatever we need to do to get that point, we need to talk about it.
I think, again, it's a noble goal. It's an incredibly important conversation to continue having. I'm a parent. My 3-year-old only has an iPad with PBS Kids on it, but that these things do scare me personally as well. So I
Thank
would
you.
love to keep working on it.
Any other questions from the committee? Seeing none, thank you for being here. Next, neutral testifier. Seeing none, as Senator McDonnell comes up to close, we had 24 letters of support for LB 106, 24 letters for the record, 21 in support, 3 in opposition. For LB 107, we had 94 letters of record, 91 in support, and 3 in opposition. Senator McDonnell to close.
Thank you, Chairman Wayne. To address Senator Geist's question about, if you looked at the amendment I handed out, it'd make it a class 4, both LB 106 and 107. It's 0 to 2 with 1 year supervision, post supervision. So if I think we probably all know a family member, a friend, a neighbor that this is happening to, either as a minor or a vulnerable adult. I'm here to try to help stop that. I believe everyone would agree on that. Now, how we get there, what we can do as preventive means, and then what we do with the punishment, I'm open to working with this committee, but the goal is to stop the digital grooming that's going on every day, again, with our family members, friends, and neighbors. I'm here to answer any questions.
Any questions from the committee? Seeing none, thank you. And that'll close the hearing on LB 106 and LB 107. Welcome. We'll open the hearing on LB 619. Senator McDonnell to open.
Mike McDonnell, McDonnell, represent Legislative District 5, South Omaha. LB 619 would expand the offense of assault to include public transportation drivers. The bill was presented to me by the men and women of the drivers that drive our buses in the Metro Omaha transit area and belong to the Transport Workers Union Local 223. There have been numerous instances of horrible assaults on these drivers while the scope and the basic duties of his or her daily employment. In these examples, there is no provocation. These men and women are simply doing their jobs and providing a service to citizens of our community. You will note this bill appears to make numerous changes in statute. This was done at the bill's drafter's request to clean up this section of law because the legislation has added certain provisions to the section of law over the years. These professions include healthcare professionals, first responders, probation officers, police officers, correctional officers, and firefighters. I have provided a memo to members of the committee that further elaborates on the rationale for these additional changes that provided updated definitions and harmonize the relevant provisions. I introduced legislation similar to LB 619 in 2021. The bill is advanced to general file and eventually designated as Speaker Priority Bill. Testimony that was shared before the Judiciary Committee 2 years ago noted these assaults endured by our community transportation drivers occur on a weekly basis without fail. Experiences shared by these individuals included being punched, beaten, spit on, and one driver even encountered an individual on his bus with a hatchet. The men and women who drive these buses and provide this service to our community are sitting ducks in their seats. They are required to focus on the road, the traffic, and the pedestrians, all while trying to observe the commuters and activate on the activity on their own bus. They have their backs to their passengers and have nothing to protect them should an incident occur. Furthermore, these horrible instances and assaults have taken place for nothing more than a driver requesting a passenger to wear a mask under the mandate or requesting a boarding passenger to pay a $1.25 fee. To add even more insult to these assaults and the reason for LB 619, these offenders are rarely reprimanded or charged for their actions because current penalties are taken lightly and have little teeth for prosecutors to pursue. To go one step further, these drivers not only endure these encounters on a weekly basis, they must then return to the same spot during the same route on a timely and routine basis throughout each day and week. Perpetrators know precisely where to find them to retaliate. As you can imagine, these common threats are beyond concerning and disheartening when a driver begins his or her shift to start their day. An increase in the penalty of an assault on a public transportation driver would send a message to these horrible offenders and actually provide a basis for prosecutors, so the repercussions would be more than a slap on the hand should someone choose to assault one of these men and women during their scope of their daily job duties, expectations, and requirements. I have a couple people here to share their stories about being assaulted. I'm here to answer any of your questions.
Are there any questions for Senator McDonnell? Don't see any at this time.
Thank
Let's
you.
have our first proponent.
Thank you.
Welcome.
Thank you. My name is Richard Schmeling, RICHARDSCHMELING. Some of you senators see me all the time when we have bills about railroads in the Transportation Committee, but this one happens to be in front of the Judiciary Committee. I would suggest there are some senators that are from rural areas, and I would suggest to those senators that you've got a dog in the fight with this bill. Because not only do we have the large metro system in Omaha that has many buses and many drivers, the Star Trend system in Lincoln that has over 100 drivers, but I served on a state multimodal task force several years ago. Out state, in the whole state, there are 54 regional transit providers. These people provide van service that comes from, say, for example, Hebron or Fairbury or Norfolk. And in addition, we have in Norfolk, Senator McKay is well aware, we established an enhanced public transit system in Norfolk recently, which I guess got some money and it's still going. The Scottsbluff recently rehabbed their public transit system within the city. There's a move to do a tri-city public transit system, Grand Island, Kearney, and Hastings. So this cuts across the board, and it's something of statewide interest. I'm the president of a group called Citizens for Improved Transit. What we try to do is to promote good public transit throughout the state. That includes public bus systems. As such, quite often I find myself riding the buses here in Lincoln. I've ridden the Omaha Metro system also. I have witnessed personally instances where there have been verbal assaults and abuse of bus drivers. Here in Lincoln, we had a problem with hiring bus drivers, and we had to cut back service. And Liz Elliott is here, and I'm sure she's going to elaborate a little bit. But one of the things that could give you pause to consider is a physical danger or verbal assault. And so I urge you to pass this bill, put it into effect, and hopefully that will mean that the drivers are safer and it will encourage people to drive public transit lines. And I see my time is over, so I guess I'll defer to the Vice Chairman and see if there are any questions.
Are there any questions? Senator McKinney?
Thank you, Senator Bohr. Thank you for your testimony. Are they, in Lincoln, at least, are they doing anything within the transit authority to protect drivers?
All right. I will answer that by indicating that StarTran has an arrangement with the Lincoln Police Department. If a driver is being assaulted or there's a problem on the bus, the driver can call dispatch. Dispatch then calls LPD, and they'll send an officer and a cruiser to meet the bus on the route. Unfortunately, that sometimes takes 10 or 15 minutes for that to happen. LPD does not have resources to put officers on every bus, on every route here in Lincoln. But there are some procedures in place. And
I guess my question, and you're kind of getting to where I want to hit, you're saying it takes 10 to 15 minutes for an officer to arrive.
it could be less if it's closer to downtown, but in the outlying areas, it could be 10 to 15.
But also assault is already a crime. It's
Yes.
already could be a felony.
Yes.
What is the transit authority doing to alert riders that if you assault a driver, it is a crime?
Okay, there are a number of ways to do this. Currently, there's a StarTran website.
No, what are they doing on the buses? So
On the bus itself.
do they have signs saying if you assault a driver, it's this crime?
I don't think there's one that's that specific, Senator.
Why not?
They do have rules of conduct for passengers. We have a new system here in Lincoln, which has just gone into effect, where there's a television screen on each bus. And they can put a message on that television screen saying that assaulting a driver or having an altercation with a driver is a crime with a penalty up.
Because the last time this bill came forward, it was pretty much said that the transit authority, at least in Omaha, wasn't doing what they were supposed to do. Law enforcement wasn't doing their job, and the county attorney wasn't doing their job. So what I don't understand is even if we increase the penalty, what guarantee that do we have that the transit authority would do their job, the police would do their job, and the county attorney would do their job? All we're doing is increasing penalties on more than likely individuals that aren't in the best financial situation or anything like that, and they may have mental health or substance abuse issues. And I'm not excusing their conduct, but what I'm saying is just increasing penalties to increase penalties may not even get to what you want to do, because these people more than likely don't even know that it is, they don't even necessarily know that the enhanced penalty would be a thing, and when currently it's already could be a felony if I punch you if I'm riding a bus. So I don't fully grasp why we need an increased penalty, but when I already could get a felony if I punch you in the face.
All right, well, let me first of all answer you this way. Because of the Americans with Disabilities Act, we have to, as a transit system here in Lincoln and elsewhere, we have to pretty much take everybody who pays the fare. Then if they misbehave, they can be taken off the bus. But if you have a penalty that's serious enough and it's well publicized, it may deter people from doing that. We have one driver here in Lincoln that I'm aware of, and he was punched, and he ended up going to the hospital. And if you lock these people up for a while, they aren't going to be getting back on the bus.
But that goes back to my point.
Yeah.
If I already can get a felony for punching you in the face, why isn't the police, the transit authority, and the county attorney doing more outreach to tell people if you punch a bus driver, you can get charged with a felony? You're saying that increasing this will increase the marketing that it's a problem. It's already a problem, and it already could be a felony. So why aren't they doing their job instead of having Senator McDonnell come every year to increase the penalty, when in reality, it's already a felony? You could already get charged with a felony for punching, spitting on, and kicking a bus driver.
All right, I'm going to defer some of this to Liz Elliott, that I'm sure is here to testify. And she may be able to answer your questions. From my perspective as a writer, it's very disturbing. And I was involved in an altercation personally where a drunken passenger was verbally assaulting the driver, and I took it upon myself to get that person off the bus. As a writer, I don't want this happening on the buses. I want to ride and have a nice peaceful ride and not see confrontation. So it's a real important public issue, and there's got to be some way of presenting it. I'll defer to Liz, maybe she can add some thoughts from the standpoint of StarTran. I don't know if anybody's here from the Omaha system but perhaps they have their own procedures in place that they could comment on.
And I understand riders want safety and drivers want safety, and I'm fully in agreement with that. What I'm saying is, the individuals that you're trying to target, that is going to be targeted with this bill, currently can be charged with a felony for assault. And currently, there is no outreach from police, county attorneys, or the transit authority to alert riders that if you assault a driver, you could be charged with a felony. And that is the problem, is it's like we're skipping a step. The transit authority isn't taking that initiative to alert the riders that it could potentially be a felony, but they would rather come introduce a bill to increase a crime when they're not even doing their job. And that's my issue. My issue isn't with you or Senator McDonnell. It's really with the police, the county attorney, and the transit authority for not stepping up and doing what they should do to protect you and others.
And Senator, the point you make is very, very good, and I think it's critical in dealing with the problem. And I would agree with you that we need to have it out there so the public knows the consequences of improper conduct. Thank you for.
Thank you too.
Yes.
Thank you, Senator McKinney. Other questions for this testifier? I don't see. Thank you for being here. We'll have our next proponent.
Good afternoon, members of the Judiciary Committee. I'm Elizabeth Elliott, ELIZABETH Director of Lincoln Transportation and Utilities. I'm here to testify in support of LB 619. StarTran Transit System is a vital division of Lincoln Transportation and Utilities. Every day, our transit team provides essential services to our community to ensure that they can get to jobs, doctor's appointments, the grocery store, and more. Our bus operators who have dedicated their careers to Lincoln Transit System are the heart of our organization. Bus operators do their job because they want to serve their community and help people. Thankfully, the majority of our riders are amazing individuals who are pleasant and appreciative of the services. However, operators often must deal with rude, angry, or even violent riders. Admittedly, bus operators are not the only service professionals that have to deal with rude or angry customers or customers with mental health issues. However, they are the only service professionals that I can think of that are isolated in a small, confined space, strapped to a seat with their backs to a group of individuals and have limited ability to move or even defend themselves. Every year, we have operators physically assaulted by passengers. One incident recently, our bus operator was faced with one passenger harassing another passenger. The bus operator told the harassing rider to stop the behavior or get off the bus. The harassing passenger walked up beside the operator, yelled profanities, and punched him in the face. The operator had no ability to protect or defend himself. Thankfully, the injuries he sustained were minor: pain, swelling, bruising. However, the fear that that could happen again not only impacts that driver, but impacts every other driver that could happen to. No one should go to their jobs afraid that they might be assaulted. LB 619 protects these operators and lets them know that their communities support them and appreciate the essential services. Therefore, we ask for the support of LB 619. And to answer Senator McKinney, who I know is not here, but currently an assault like that is a Class 1 misdemeanor. So at most, it's up to a year in jail, up to $1,000 fine, or a combination of both. You also could be charged under the city ordinance, which is a city assault, which is only up to 6 months in jail, up to a $500 fine, or a combination of both. I apologize, I haven't been in the public defender's office for about 6 years now, so memory I have to go back to. But only does it become a felony if you have an instrument, a deadly instrument. So if I had brass knuckles and punched you, and there was serious bodily injury, could that potentially become a felony? And that could be a second-degree assault or a first-degree assault.
I'm gonna stop you because
Thank
of
you,
the red,
sorry.
but then I'll ask you.
Yes, sorry.
So in that instance, was there a prosecution of that assault?
There was, we do have a great partnership here in Lincoln between the Lincoln Police Department and the county attorney or the city attorney's office. It could be prosecuted under either state statute or city ordinance. And so assuming they can identify and find the individual that happened, we have had success with having those prosecuted. The penalties, though, are typically of that misdemeanor and fine or minimal jail time.
So the hatchet situation, that's a felony.
Potentially, it could be. If they're just carrying.
I think I remember the description and it was threatening with the hatchet. Don't know
Yes.
exactly what else happened. I can't-
Right, if they're
It
threatening.
was a couple of years ago, I think, that I heard that one. So the face punch was prosecuted. You said if they can find them, they'll prosecute them. That, of course, whether it's a felony or a misdemeanor is irrelevant to whether they can find them.
Exactly, it is.
So I think what Senator McKinney was asking, and it's something that I asked in previous years, was, first of all, right now, couldn't we improve driver safety like overnight by putting up a sign in all of these buses that says, because apparently there's not a sign that says assaulting a bus driver is punishable by, is a crime punished by up to a felony. Why don't we have a sign like that?
We do have, as Mr. Schmeling was indicating, we do have codes of conduct that are posted, and that type of behavior is listed on there as prohibiting it. I
think we should
don't
highlight it.
believe.
I think we should highlight it in a sign. Do we have a sign that says it? Like, if we pass this bill, we should do it. If we don't pass this bill, we should do it. Before we pass this bill, while the bill is being passed, we should do it. There should be a sign.
And we could definitely post a sign that says assaulting a bus operator is a crime. I don't know that we could go so far to say it's a felony because
I said
punching
up
someone.
to a felony, which it would be, because if you did it with a weapon, it would be a felony.
Potentially, yes, we could do that.
So,
yes.
I mean, I'll print it out on my printer at home if you want me to. I mean,
We
we should
do.
have those signs. We should have those signs up tomorrow.
And we do have a number of different signs. I would submit that the posting another piece of paper on there will go unnoticed and will not make a difference. However, we have just recently, in the last 2 weeks, installed infotainments in our system, and that is one that we are going to post on there. It is a scrolling electronic board that will be on there. It would be the focus of attention for our riders, rather than searching, because there are a number of different FTA regulated postings that we already have on our buses. And so adding another piece of paper is likely not to have any results.
I mean, it would be worth a try.
It would be worth a try, yes.
The other thing I asked about was whether or not we could do something to protect them actually with, in other places I've been, there's, and I did some research on this, there's cages you can put around folks, there's plexiglass, things like that.
And we do have some of that. We installed some of that during the pandemic. It is something that for some operators creates a very claustrophobic situation because they're even more enclosed in a small space and they are set up, but there is that fear that if they're in an accident, now they're even more trapped. And so that is something that not all, some operators absolutely have asked for that and we've discussed it, but some are very much against that because of the feeling of
So it's not.
It's an option.
All right, but let's put some signs up. Are there questions from the committee? Let's start with Senator Decay.
Quick question. This is going a little bit farther down the road. This bill is to protect the drivers and stuff. What happens if a driver's punched or rendered incapacitated while the bus is moving, hits a power pole, and passengers get hurt? Where does the penalty process go from there?
There could be a number of different charges I believe that a prosecutor could bring. Obviously, it would depend on the level of injury, up to and including if someone had died.
in that crash, there could be, as was spoken earlier on a different bill, manslaughter potentially, or other charges. But there could be a number of potential crimes that could be prosecuted.
Senator Holcroft.
Thank you, Vice Chair DeBoer. Can you go ahead and finish your thoughts on what constitutes a felony? I mean, you started off by saying a weapon.
Definitely. No, absolutely. So there are first degree and second degree assaults that are felonies currently under our code. The second degree assault is you have to have a dangerous instrument and bodily injury, and then first degree assault is serious bodily injury. And so the typical bruising, swelling, black eyes would not rise to the level of a serious bodily injury.
Okay, thank you.
Thank you.
Thank you, Senator Holcroft. Senator Geist.
Okay, I have a couple questions. There are other city officials that would fall under this, like I know I'm just reading the bill, a peace officer, a probation officer, firefighter, emergency. So it's not out of the norm for a city employee to have, to be treated, I guess, a bit differently than just an average citizen.
That is correct. Currently, the statute includes the healthcare officials, the firefighters, the police officers, probation officers as well. And part of it is that heightened job requirements. And as well, I think what sets transit operators apart is the fact that they really, you and I, if someone would walk up here and try and punch us, we could hopefully run away, leave, I could get away. The difference with transit operators is they can't just run away. The bus is running, or even if it's not moving, they're still confined to their seat. They're strapped in with their seat belts. They're backed into a corner, and there typically are a number of individuals behind them on the bus already riding. So it's an exceptionally dangerous situation, not only for the rider, but the passengers.
Okay, so I'm just putting myself in their place, and I'm thinking, okay, so what would I do to defend myself? Can I defend myself?
You could, if you could put your hands up or swing, but you would not be able to stand up. If the person's hovering above you and you're in a seated position as an operator, you're clearly in a position that's not likely to have much risk.
Well, I would probably, I don't know, I have kind of that streak. I might try to do that. But in their, like, in their profession, can they defend themselves? Is that?
They can. We definitely tell them to do what they can. It's just limited given where they're at.
Sure. Okay. Thank you.
Thank you, Senator Geist. Other questions for this testifier?
I do.
Oh, Senator Decay.
Thank you. Off of what Senator Geist asked, if they could defend themselves, can they be carrying a can of mace or something with them to protect themselves at that point in time?
So on our buses, we do not allow, currently, we do not allow any types of weapons or sprays or anything.
Thank you, Senator Decay. Other questions? Thank you for being here.
Thank you.
Next proponent.
Good afternoon, senators of the Judiciary Committee. My name is Tuahe Chang. That's Tuahechechang. I'm here on behalf of Transport Workers Local Union, Local 223. I want to thank Senator Mike McDonnell for supporting and bringing this bill forward. This is going to be our fourth shot at this attempt. Last year, we were very close. We just happened to run out of time, and the bill did not get voted on. I'm here to testify, also to bring to light, just like how these individuals had stated, that our jobs are not like many others. You know, we are professionals that are servicing a community of those that are in extreme poverty, those that are in a state where they have no help with mental illness. We have individuals who are, you know, addicts and drunks. So we're dealing with people that are highly agitated, especially in this economy, the way inflation is. We're dealing with people that are dealing and battling demons on the daily. And so I've been a bus operator for the Transit Authority of Omaha, Nebraska for 7 years now. Early into my career, I was assaulted in the line of duty. One evening while driving, I come up to a stop. I open my doors. The gentleman comes in. I inform him, hey, the fare is $1.25. He does not have the fare. He spits in my face, and then he lunges at me and connects, and it's a fight. He's on top of me. I'm only about 5 feet tall. This gentleman was 6'5", towered over me, right? I'm sitting there in my seat. I'm strapped. I'm clawing, scratching, pushing, trying to get him off of me, you know. And while this attack is ensuing, I remember at one point looking back, and all the patrons, other than customers that are riding, they all have their cell phones out recording this. No one comes to my aid. You know, in the event that an officer does come, that response time is about 10 minutes. So I just wanted to bring you to light that our job, you know, it's very scary. You know, we have to come back to that same spot, you know, the next morning. We might see that same individual over and over again. And so it's very scary. And the word on the street is that, yes, if you assault a bus driver, it's a slap on the wrist. You know, for instance, my case, the guy made a plea bargain with the city prosecutor. He walked away free without any incidents. You know, and I still have to see this individual daily. It brings a lot of post-traumatic stress to me. And you're going to hear a testimony from one of our operatives who recently was assaulted, and her case was very severe. But just if you guys have any questions, I'll be more than happy to answer any of your questions.
Thank you for appearing here. Senator Geist.
I do have one. And Mr. Chang, thank you for your testimony. And thank you for your service to your community.
Thank you.
What percentage of people ride your bus that you're concerned about?
All of them. The moment you open the door, you don't know if that individual is a good person or a bad person. You don't know if they're on drugs or they're drunk. And I would say about 95% of the time, we're dealing with those kind of individuals. Yes, we have the grandma that needs the ride to go to her appointment or to go to the grocery store, who I'm very happy every day to pick up. But we are also very scared of the individual that we pick up at night who's been drinking a fifth of vodka right before he gets on. And now he's highly
So with that individual, how many, I mean, are those the majority of the people you drive around?
Yes. And I implore any one of you senators to come on board and take a ride on the public transit bus so you see firsthand what the operators are dealing with daily. You know, unlike many of your jobs where you can ban and bar somebody, this is a public service. We are providing public service to the community. There is no ban and bar. You know, if someone assaults you tomorrow, spits on you tomorrow, he's getting on your bus again tomorrow, and he's going to antagonize you and say, haha, nothing happened. You know, it's very scary. And I want my brothers and sisters, you know, those that I work along with to be protected. You know, it's not that I want to we want to fill up your prisons or jail cells, but we need this as a deterrent because it is not a felony unless, like she stated, that you are obstructed with a weapon, you know, a knife or something like that, right? But if it's just your fist or you spit on or something like that, we had a driver, he got slapped upside the head with just like a water bottle, or, you know, drinks getting thrown in your face or trash getting poured on you, you know. But we need your support. We need your support. We need your protection in passing this bill so that we can be protected. Flight attendants, nurses, they are protected, okay? Why are not bus drivers? We are just as important as first responders. You know, our eyes and ears are of the community. You know, there are many of our bus drivers who have helped find lost children. You know, we navigate the city for those that can't find, you know, where to go. So we need your help and your support.
Thank you.
Thank you, Senator Geist. Other questions? I have one for you.
Yes.
Just brought up what you were just saying, Senator Geist. Do you want somebody, you know, throws trash at you to be the same level of offense as someone punches someone in the face?
Well, that's gonna be a lot of gray area, right? But, if they know that, if I physically touch you and harm you and cause bodily stress to you, that it is a felony, it's probably gonna, give them a second thought, like, hey, if I do this, I'm gonna go to jail,
Yeah.
Versus right now, they feel
Right.
like,
So I guess what I'm asking is, would you support a carve-out type of thing where it said something like, if you don't physically contact the bus driver, then it's not a felony? So like if you just pour a Coke on their head, I have a Coke here, which obviously is terrible. But should someone go to jail for that many years for that versus actual punch in the face, which is a really serious thing? I just wondered what you thought about that.
well, like I said, that those are gonna be very isolated incidents,
Yeah.
but I'm on the normal, verbal assaults happen just about every other trip where we turn around the bus, but verbal assaults lead to,
Yeah.
physical assaults. So, Coke being poured on you can lead to,
Sure, but unless it led to it, would you want it to be treated the same way?
I just want us to be protected, and I just want this to be used also as a deterrent that, hey, if you assault a bus driver, that you physically cause bodily harm
Yeah.
to the bus driver, that there will be consequences.
Thank you so much for
Thank you.
testifying and for your services to Omaha.
Thank you.
I'm in
Thank you.
Omaha. I appreciate it.
Thank you guys for your time.
Oh,
Go ahead.
there is one more, Senator Decay.
Is there any protection for you if somebody verbally assaults you without hitting you, that you could say, hey, that person's not going to be able to get on my bus tomorrow
No,
morning?
because just for verbal assaults, no, because we are a public service, so we are providing public service to anyone. We cannot deny someone a service, on their age, gender, religion, race. Just because it's Senator Decay, I hate you, I have an axe against you, you can no longer ride me. We cannot do that. So verbal assaults, it might have happened today, and I see you again tomorrow, and now I see your face again, I'm agitated. Oh, because of you, you said something to me, or because you made me late, now I'm gonna assault you the next day. So it's like, it doesn't, we don't have anything right now that, would help, but we need this so that it would be a deterrent, I believe, and, we need to be protected, just like, nurses or flight attendants. Thank you. Thank you all.
Next proponent. Welcome.
Good afternoon, senators. This is the first time I've been on this situation. My name is Blanca Acosta, Acosta Diablos, BLANCAD, ABA, ACOSTADE, ABALOS. And you got the story right there. And if I read it, it might take more than 3 minutes. So you can read it out there. It happens on July 22nd last year. And to make it shorter, if you want to read it, you go ahead. I was assaulted by this kid. He was 15-year-old. And if I don't prosecute him, he wouldn't be on Wyoming for the rest of his age, which is going to be 18, or I don't know his age here in Nebraska, because I persecute him and I follow the court, and he will be there until he turned 16 in December. And I tried to defend 4 girls that he tried to beat him up. And I not even get off the bus, but I blocked him off with a shield. So I called dispatch, follow the procedures, Metro's procedure, and I just turned myself, grabbed the phone, and he stopped picking me up. He got his friend, which is just right there, and tried to, he put me down, kicked me, and thank God that day don't have nothing on hand. But he was on what's called uh, probation. And when I went to my last court, guess what? They got him with the gun. And when I went to the court, he was on chains on his legs. And the state got his custody. But if that day he got a gun, I won't be here. I won't be a grandma. I won't be a mother. And I won't be a wife. I won't be here telling you this story because he might be with a gun. Who knows? But thank God that doesn't happen. So these people, he was on drugs because he said he don't know what the heck he's doing. And I see a lot of stories about drugs that can be prevented.
Thank you for your testimony.
And this is the story right there. I don't want to read it because I don't have a long time.
We have it. Thank you very much for passing that out for us. Let's see if there are any questions.
And I still got anxiety. I can't, when I got somebody on the bus, I still got anxiety, got headaches. I got a bit up on my head, bruises all over my body and my back. And 3 months out of work. Thank God, we have workers' comp. So
let's
thank God this guy is not here. He's on jail.
Let's see if there's any questions. Are there any questions? All right, thank you for being here.
Thank you.
Next proponent. Is there anyone else who would like to testify in favor of the bill? We'll move to opponents.
Good afternoon again. My name is Spike Eicholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association in opposition to LD 619. The proponents and the support for the bill is based on the assumption that if we make all assaults on transit drivers felonies, that's going to have a deterrent effect. But if you listen carefully to the proponents, they explain that the people who are assaulting them are often intoxicated, mentally ill, poor. Senator DeBoer asked one of the proponents if they put up signs or they somehow notify people who ride buses that they may be subject to prosecution, even including up to felonies. They seem sort of uninterested and non-committal of that. And then simply said at the end of it, I think, well, that'll just be another piece of paper that they won't read anyway. If they're not going to read pieces of paper on the bus, people are not going to look up what the statutes provide for penalties. What this bill would do would make every assault on a transit driver a felony. And right now, a third-degree assault is if you cause bodily injury to another person, regardless of who they are, it's a misdemeanor. 0 to 1 year imprisonment. That's up to a year in jail. If these things aren't being prosecuted, if they're not being investigated, then making it a felony is not necessarily going to be the same, make it any more likely to be investigated or prosecuted. We haven't heard anyone from law enforcement that explain that's going to be the case. We haven't heard anyone from prosecutors' offices that explain they're going to prosecute these things more seriously. That's not the case. What it will do, it will expose a certain group of people, a certain demographic, to felony prosecution for every confrontation, every incident that happens on a bus, similar to your interaction with a police officer. No disrespect to the transit drivers at all. I understand their predicament, at least I appreciate their predicament. I may not really understand it. But the reason that we offer protections to police officers, first responders, is because they have certain requisite training. They have powers that are given by the state to them. Police can kill people. Police can detain people. Police can arrest them. They have de-escalation training every year. They have training on recognizing mental illness and intoxication and working with people in that state and de-escalating those situations. That's not the same necessarily for transit drivers. There are other responses beyond carceral responses, beyond simply increasing a penalty that would give them, I would submit, a false assurance they're going to be any more safer. They are structures, they are signs. If you look on page 10 of the bill, lines 7 through 11, the legislature's actually done this when it comes to healthcare providers, specifically direct hospitals and other licensing entities that are health clinics and so on to post a sign prominently with certain advisements. That's something that could be done alternatively. Somebody asked, I think Senator DeVore asked, if there are any kind of structures or protections, and again, it seems like there really isn't. And that's something that other jurisdictions have done to protect transit drivers. I'll answer any questions if anyone has any.
Any questions, Senator Decay?
Thank you. Thank you, Spike. What can we do? You know, we're talking a little bit difference between transit drivers and first responders. What can we do to let them know that they can be assured that they're going to be protected to fulfill their duties as a driver to the public?
Well, one thing, I suppose you could require some sort of prosecution. I don't know if the legislature can really make prosecutors charge crimes, but that's one thing. If these things that are charged, that could be charged as misdemeanors not being pursued, there really isn't anything the legislature can do. These things are crimes. You cannot punch a bus driver. You simply cannot do that. If they are getting pled down and dismissed, and you hear some of the proponents say that the cases were charged, but they pled it down, it was just a slap on the wrist, that's not anything the legislature can really correct. So, but other things they could do, we could appropriate money for local political subdivisions to invest in protective equipment on buses with the condition they've got to post signs that notify riders that you will be subject to prosecution if you assault or threaten in a menacing manner, which is a type of third-degree assault, a bus driver, up to and including felony offenses. That's one thing you could do.
If I understand some of the earlier testimony, these are getting watered down to the fact that they're light enough violations or subject to violations that we're not going to mess with them because we got too many other bigger issues to deal with. Why don't we make these big enough issues that they can be dealt with?
Because what you're going to be doing is you're going to be exposing people who rides a bus. It's poor people generally, people who can't afford vehicles. People, if you heard the proponents testify, who are mentally ill. It's demographically people of color. You will expose them to felony prosecution. And in my written testimony, I mentioned some of the statistics that we have. We already incarcerate a lot of Black people in this state. And this is one of those situations where on the face, this is nothing at all racial about it. But this is a crime that we're going to bump up to a felony. If the prosecutors, and I can't speak for them whether they're not here, but I think it's conspicuous that they're not. This is a bill that they're going to have to deal with. If we bump it up to the felony level of prosecution, that's something they're going to have to deal with because there is no misdemeanor option if this bill passes. I don't know that they're going to be taking it more seriously. I don't know.
Is there any space in between a misdemeanor and a felony where we can make it worth prosecutors' time to protect these people?
I think it's worth their time if they want to do it. I mean, 0 to a year in jail is not necessarily a small consequence, right? If you talk to your local jails, I mean, Douglas, Lancaster County, they're essentially full already, right? So people are serving a lot of jail sentences in our jails. As far as reforming the criminal code, I've asked senators to introduce bills to moderate some of the felony level prosecutions to provide for certain things. I mean, you've heard in other contexts where if you have a felony that's got a mandatory minimum, for instance, perhaps we could have a safety valve where they can deviate down, and you see the dilemma now. You know, this is why I'm here for these things. There's nothing against these people, I get it. But if I don't show up and say, no, don't do this felony, because when it goes on, it's just impossible to modify it later. That's just a predicament we're in.
Well, and I think we all want to get to the same place that these people are protected, that they know that when they go to work in the morning, that just like a first responder, they're going to be able to go home safely to their families.
Thank you, Senator Decay. Other questions? Spike, I do have a question for you. Is that assault level is it for throwing trash, liquids, spit?
If you spit on another right now, it's a misdemeanor.
Okay.
Unless there's a communicable disease and you sort of know that you have
Yeah.
some sort of disease. If it's throwing something at somebody, if it's threatening someone in a menacing manner, that's a type of third-degree assault. So third-degree assault is if you intentionally, knowingly, or recklessly cause bodily injury to someone else, or you threaten them in a menacing manner. And that can be a verbal threat, it can be a non-verbal threat. It's got to be perhaps something more than just throwing trash. It depends on how you guys throw it. If it's an aggressive baseball pitch type thing, that might be considered threatened in a menacing manner.
In the bill as it's written now, would any of those things become felonies?
Yeah, if you could show that the third degree assault was done in a menacing manner, or the threat was done in a menacing manner, if you look on page 2, line 15, one of the listed offenses in the enhancement stuff is assault in third degree pursuant to section 28.310. I know there's a lot of text to the bill, but I think what revisers probably had to do, because we've added the certain categories of individuals where this enhancement applies, it would apply to anyone who commits any of these listed crimes. It's just bumped up one more level of enhancement. So it goes from class 1 misdemeanor to class 4 felony. So yes, it could be, to answer your question.
Okay. Thank you. Other questions? Mr. Eichel? Don't see any. Thank you. Next opponent. Is there anyone here who would like to testify in the neutral capacity? Senator McDonnell, I'll note for the record while you're coming up that there are 2 letters, one in support and one in opposition. Senator McDonnell, close.
Thank you, Senator. All right, so trying to answer some of the questions and sum this up. In the past, people that have sat in your chairs, that have served in the legislature, have decided to take a police officer, a firefighter, a nurse, because of the nature of their work, that if they are verbally assaulted, they have something thrown on them, physically assaulted, we're going to treat that at a higher level because of the nature of their work. What we're asking is to add the transportation workers to that, because they're there because of the nature of their work. Now, it was discussed about more protection, more signage. They don't always just sit in their seat and drive. They do have duties that they help people on and off of. Not opposed to the time I think we can inform people, but I think some of these people, they do have duties that they help people on and off of. Not opposed to the time I think we can inform people, but I think some of these people, regardless of the signage, if it's a police officer, firefighter, nurse, even though I agree with the signage, I don't know if that'll deter, but let's say. What we have to do is, I think, decide is, do we want to add the transportation workers to that list? And also something that I should have brought up in my opening was, this does not include school bus drivers. That was discussed before. But so talking about the men and women of 223 that brought this, and then others that have come and shared their stories with me and testified in the past, is that what they want is to be protected and looked at as if we would, as we have in the past, a police officer, firefighter, and nurse, because they are being assaulted just by doing their job, not based on anything else position for someone who wants to take advantage of them possibly sitting there, asking, as I said, for the fee, trying to stop a fight on the bus, enforce a mask rule because of the pandemic, all they were doing. So, and also they want someone made example of. Yes, there's certain people that actually, and if you think about the people that police and fire and nurses are dealing with, it's the same cross-section of society that the bus drivers are dealing with. Some do have mental illness, and that should be taken into consideration. And I think it was talked about earlier with Senator Decay. If you want to look at a class 4 felony, which we talked about earlier, with 0 to 2, and then 1 year post-supervision release, okay. But there's some people, again, if John Doe calls a bus driver Jane Doe a name versus throwing a pop versus a punch versus hitting them with a hammer, of course, there's different levels. But they want to actually not only be punished, but let people know that different levels. But they want to actually not only be punished, but let people know that the punishment is going to happen to others if they decide to do that. And you're talking about 99% of the people that ride the bus just want to get from point A to point B. That's all they want. They don't want to see their bus driver that they've gotten to know, because we've talked about the negative about having that route and that time where the same person, if I want to assault somebody twice, I know where they're at. How about all the positives for the people that ride that bus every Monday, every Tuesday, at the same time, and they get to know that bus driver? They don't want to see their bus driver assaulted. There's so many reasons to do this based on, and we have statistics with the courts based on how it's helped with police, fire, and nursing. So that's what we're asking. We're asking to add the transportation workers to the same level as we've in the past to those other professions.
Are there any questions for Senator McDonnell? Senator Geist?
I maybe not a question, but maybe more of a comment. I'm impressed that these guys and gals come back every day to do their job when they're sitting ducks in that kind of a confined area. And I guess my perspective would be that they're employees of the city. They're employees of government. And I do think that they're worthy of being protected, whether that's a sign or a cage or whatever. But anyway, you're welcome to comment on that. This is a frustrating bill to me.
No, I agree. And again, not discarding any level of protection if it's a sign, if it's the cage, but the cage won't always protect them the whole time when they're doing their job.
Sure.
But also the idea of just showing them, I think, the due respect and giving them credit for doing the job, and also saying that we do want to protect you. We do want to send the message and, of course, the deterrence level of it.
Other questions for Senator McDonnell? Thank you, Senator McDonnell. That will end our hearing on LB 619 and bring us to our hearing on LB 649, shockingly also by Senator McDonnell.
I know this will make you all happy. This is my last bill, and it's my last bill of the year. I mean, with the Judiciary Committee. Still got a couple of appropriations. Thank you. Thank you, Vice Chair DeBoer, members of the committee. My name is Mike McDonnell, McDonnell, represent Legislative District 5, South Omaha. I come before you today to present LB 649, which seeks to update the modernized Nebraska's arson statute. So I have introduced this legislation on behalf of the Attorney General Hilder's office in an effort to help facilitate and implement these changes. In a broad sense, LB 649 includes updated definitional terms used in Nebraska's existing arson statutes, as well as an additional provisions that will make Nebraska's arson statutes applicable in a greater number of intentionally set incendiary fire scenarios. The legislation also includes a penalty adjustment that was overlooked in a previous sentencing reform and allows for sentencing enhancement under certain circumstances. More specifically, LB 649 eliminates the definition for building in a sections 28-501 and replaces it with the term structure in order to broaden the instances where Nebraskan arson statutes are applicable. The broader definition is necessitated by the fact that human lives are being risked by fires set in locations that do not fit within the current existing definition of building. This change is also made in sections 28-520, first degree criminal trespass, and 28-524 graffiti, as both sections are just as reliant on these terms. LB 649 adds burns and causes to be burned to the list of acts prohibited in various sections in order to harmonize each of the prohibited acts listed in section 28-504. The bill also maintains a fire to the list of acts prohibited by all the Nebraskans' existing arson statutes in order to hold persons criminally accountable for escalating a fire even though they did not set the fire. Last, LB 649 adds a definition for public safety official and allows the applicable sentence on an arson offense to be enhanced one penalty classification higher if the offense committed causes a public safety official to sustain serious bodily injury. It is reasonable, foreseeable that a firefighter or first responder could be injured in the line of duty when someone deliberately makes the choice to set something ablaze or blow something up. This bill also makes arson in the second degree a Class 1A felony as opposed to a Class 3 felony due to the oversight when LB 605 was passed in 2015. During my time as a firefighter, I witnessed terrible accidents and horrible crimes as a result of fire. LB 649 further addresses intentional acts of arson by eliminating gaps and gray areas that currently exist within our laws. Assistant Attorney General Mike Geining will be testifying on behalf of the Attorney General's office and to provide insight and answer any questions from the committee.
Thank you, Senator McDonnell. Other questions for Senator McDonnell? Don't see any.
Thank you.
First proponent.
Good afternoon, Vice Chair DeBoer, members of the committee. My name is Mike Guinan, Mikeguinan. I'm the Criminal Bureau Chief for the Nebraska Attorney General's Office. I am here on behalf of the Attorney General's Office and Attorney General Mike Gilgers in support of LB 649. We originally proposed LB 913 in 2020 to address shortcomings in Nebraska's arson statutes. In its current version, LB 649 incorporates several changes to the present arson statutes. First, Section 3 proposes that second-degree arson be amended to a Class 2A felony, which would provide for a penalty of 0 to 20 years. Prior to 2015 legislative changes, first-degree arson was a Class 2 felony, which would make it punishable by 1 to 50 years, and second-degree arson was punishable as a Class 3 felony, again, 1 to 20 years at that time. Arson in the first degree requires proof that the actor knew or should have known that a person is inside the building. The fire is started. Arson in the second degree occurs when the building is unoccupied. LB 605 in 2015 restructured the penalties for many offenses and created the 2A felony classification. 2A felonies now carry a penalty of 0 to 20 years imprisonment. LB 605 did not, however, change the penalties for arson in either the first, second, or third degree. Consequently, the penalty for arson in the second degree was effectively lowered from 1 to 20 years. Now it carries a penalty of 0 to 4 years. The penalty associated with arson in the second degree in which a building or property within the building is intentionally damaged or damaged in the perpetration of a burglary, robbery, or felony criminal mischief is not commensurate with the significance of the crime, particularly given the severity of the loss of property and the risk of substantial bodily injury to firefighters. Originally, we brought this as a result of an arson homicide case that we dealt with several years ago. In that case, two gentlemen showed up at the victim's house in a rural countryside late at night. There was a knife fight. Our victim was stabbed 15 times. The next day, one of the men that was involved in stabbing the victim came back and burned the house down. We charged first-degree arson in that case along with murder. Ultimately, there was no clear indication from the case law, inside or outside the state, that a person included a dead person. So therefore, the court did not allow us to move forward on the first-degree arson. The court allowed us to move forward on second-degree arson, which lowered the potential penalty, or did lower the penalty from 1 to 50 down to 0 to 4 years. The other piece that I'd like to mention that Senator McDonnell had mentioned.
I'm going to note the red light and then ask you what the other piece is, just because if you can do it in 2 or 3 sentences, please.
Sure. The other piece, the public safety officer, in that particular case I was just talking about, what happened is when they learned that there was an individual inside the house, whether alive or deceased, it changed the way they fought the fire. Instead, they were going to, since it was out in the countryside, they were just going to let it burn and collapse on itself. When they learned that there was an individual in there, that changed, their risk level went up substantially, because now they start entering the building with the danger of collapse and all the rest of things that follow.
Thank you.
Yes.
Are there questions? So you and I have talked about this bill before.
We have, Senator.
And I still have the same concern that I had before, because I see that you still have a very broad definition of structure here that includes a tent, A vessel, which, as I recall, last time I had a coffee cup with a vessel. And I was like, this is a vessel. You could put a piece of paper in here and light it on fire, and now I've committed arson. So can we talk more about structure, and can we maybe make that a little cleaner? Because I understand that you're trying to broaden the definition of arson, make arson broader. In principle, I understand why you're doing that. This is real broad. So is there some way we can clean up the language of this?
Well, and we did talk before, and I know that you raised about the vessel. I think you also had an example where you light a piece of paper and put it in a fireplace.
There was something about that.
That piece was stricken out
Oh,
in this
great.
version,
Good.
so there has been some.
Good, we're getting there.
And so Senator, yes, I understand your concern with the word vessel. Again, I think at that time I mentioned that we borrowed some language from different states. I think that might have been
I
from
just think we
Florida.
probably need to clean this up a little bit because it's real broad now. So that pretty much any, like, we have a fire pit that we've built up that under this would be a structure. And we put fires in there on purpose. It's meant to have fires. So, I mean, we probably need to clean this up.
Sure, and there certainly is room, Senator, to work on cleanups. We'd be happy to do that.
All right, thank you. Any other questions? Okay, I don't see any.
With that, yep, thank you.
Thank you. Are there any other proponents? Is there anyone here in opposition to this bill?
Good afternoon. My name is Spike Eichholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association. So as the introducer and the proponent explained, what this bill does is a couple of things. It increases the penalty for arson. I think the justification or the argument that's made is because it was something that was an oversight in 2015 with LB 605. I was just starting to do this then, so I have to admit I don't remember everything, but I'm pretty certain that was not an oversight. That was a deliberate decision to adjust the penalties for some of the property crimes, and this is one of them. The bill also broadens the definition fairly significantly, which is another reason that we are opposed to provide for arson, not just for a building, but something called a structure, which is defined on page 2, lines 19 through 22, which would include any building of any kind, any enclosed area with a roof, and any real property and appurtenances to which the building or enclosed area is attached, any tent or other portable building. This is, as Senator DeWart alluded to, this is very broad and it would expose a lot of people to felony prosecution, not only just for fire to a structure, but fire within a structure. You know, on their O Street in West O, there are people living in tents, and in the winter they have fire. Now, sometimes those things may burn and it's dangerous, obviously, to fire people, but it's not the same we would submit as an actual building or an apartment complex or some other thing where people may live. This is one of the bills that we oppose for increasing penalties. The last testifier, the proponent testified to explain that this was done in response to a case a few years ago that the Attorney General's office prosecuted where they could not establish the arson conviction, at least the first degree arson conviction. I actually looked up that case by looking at what we talked about last year. If you look, and I attached the news article, the people were still nonetheless found guilty of other related crimes, and they got a pretty significant sentence. So I want to mention that so the record's clear that without this bill, they were each, I think the father and son got 42 to 64 years, and the other one got 40 to 60 years imprisonment for their involvement because they were found guilty of second-degree murder and perhaps some other crimes as well, including a third person who was found guilty of an accessory. I just mention that because when you look at one crime and you think to yourself, oh, this isn't really that big of a deal, you have to consider, or at least appreciate, the acts that might result in this crime and the other crimes that are impacted and the other crimes that people commit when they do these kind of things. I'll answer any questions if anyone has any.
Are there any questions for Mr. Eichel? Senator Blood?
Thank you, Senator DeWart. Spike, can you repeat what you just, I'm having trouble hearing you. The last
Sorry.
part said it's for the, it's not your fault, it's the room's fault.
You know, when you're asked to, when senators are sometimes given a bill, and they say, hey, let's increase the penalty for this because this is only 0 to 3 or this is only 0 to 4. One thing that you have to, that I would respectfully suggest you should appreciate that if you increase the penalty here try to realize how this crime might be charged and what other crimes might be charged with it. For instance, if you set fire to a building and there's human remains in it, and you knew there were human remains in it, chances are you've committed some other crimes, as the example that I handed out happened. In other words, the Attorney General testified earlier that they weren't able to show first-degree arson based on the fact that the human remains are not considered a person under the current definition of arson. However, the people were involved in a fight. That fight resulted in a stabbing, and somebody died, and they were convicted of second-degree murder and got a pretty significant sentence. So I just wanted to mention that.
Thank you. Other questions? Senator Decay?
Could it be defined as different than a structure as something that is built like a fireplace, fire pit, anything that isn't built to use fire in, trash can, whatever, as a structure in that point?
Yeah, if you look at the page 2, lines 3 through 11, that's the current definition we have now of building, which would exclude those things. And that's why we have a problem with that, because it redefines it to include structure to mean buildings and other things.
The other thing, you mentioned about homeless people living in tents and stuff, and those tents sometimes start on fire. Those wouldn't, in my mind, wouldn't be considered an arson. Those are an accident that happened. It's not. So we got to define what is actually arson or what is an act of nature or whatever.
That's right. And respectfully, and that's probably it is as it is now. But if you look on page 3 lines, starting at lines 5, that paragraph, the person sets fire to any structure or property contained inside a structure or maintains a fire. It does not necessarily mean that you need to do so accidentally or unintentionally. You simply need to set fire to it.
I'm done.
Thank you, Senator Decay. Other questions? Thank you, Mr. Eichholt. Senator, are there any other opposition testimony? Anyone in neutral? Senator McDonnell, as you're coming up, there was one letter in support. Senator McDonnell blissfully waves. Closing.